WBC 87 of 2022.
The writ petition disposed of allowed. The respondents will proceed to take all steps necessary as prescribed under the communication dated so and so and execute these steps specifically and implement the same in this time-bound manner. Amount deducted from the petitioner at the rate of so and so for GST shall also be refunded. Let this exercise be carried out within 3 months from the date of receipt of a certified copy of this order.
Deeply obliged.
Yes.
WBC 455 of 2024.
Impugned order dated so and so is interfered with, set aside, and the matter is remanded back to the concerned authority to rehear the matter upon giving an opportunity of personal hearing to the writ petitioner. Petitioner will appear before the authorities concerned within 15 days from the date of receipt of a certified copy of this order, and thereafter the authority concerned will rehear the matter and thereupon pass appropriate orders. Writ petition accordingly allowed to the extent indicated, disposed of. No order is to cost.
Deeply obliged.
Make picture. Lord, I'm praying for listing of a matter for admission, Lord. It's regarding compulsory retirement on next Wednesday, my Lord.
Next Wednesday.
13th.
It is a fresh matter.
No, my Lord, old matter. Last time it came in 2023. He's
Let
going to
it be
retire.
on Wednesday. Already a lot of matters are there. 18th or 20th?
20th.
20?
I have the same pair. Already on Monday for admission, madam. It is a case of 23. Initially, it was
18th. 18th August.
20th August.
20th August.
11 is not.
20th August.
If 11th August.
Huh?
11th.
What element?
11th August.
11th August. Already 11th August.
Madam.
Yes.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 33, lordship. Lordship,
33.
the matter may kindly be passed over for the day, lordship.
My Lord,
33.
I am for the
33,
petitioner,
Lord.
my Lord. This is the pension matter, my Lord. And we have already received the affidavit in opposition. So I'm praying for date may be fixed, my Lord, this whole time.
You have filed any rejoinder? You want to file a
Not
rejoinder?
yet, my Lord, their affidavit has not come to the court, my Lord.
Huh?
They are going to file the affidavit in opposition today itself, my Lord. And I have received the copy in the month of April, my Lord.
Item 33, on the request made by Ms. So-and-so, appearing for the CGC, submits that the matters be adjourned for 2 weeks, enabling them to file the affidavit. The petitioner is also given liberty to file rejoinder if so advised. List after 2 weeks on 29th
My Lord.
August.
Wait, much obliged. Item number. My one prayer, my Lord, I'm praying for listing to read petition in admission column, my Lord. And next week can be any date, my Lord.
Next week, let it be on 18th.
My Lord.
18th.
My much obliged.
Wait, item number 2, my lord, we have filed an affidavit.
Item
Item number 2, my lord.
2.
We have filed an affidavit. I may be allowed to call the same for the record.
Why did you file it today?
Yesterday.
Why?
Because the matter was not fixed. It was fixed for the next week. Because certain facts were there which deserves your lordship attention. That is why we filed it yesterday.
But we did not get the opportunity to see it.
Or your lordship can do it, my lord.
We'll have it some
Next week, your lordship.
11th.
11, my lord.
Right.
11th.
Item 2 be listed on 11th
Along with
along with the affidavit, additional affidavit.
affidavit in reply.
Affidavit in reply stated to have been filed by the writ petitioner yesterday.
Yes.
Stop. The registry will trace out the affidavit and connect it to the case record.
Obliged.
My lord, one pending matter, my lord, release of retirement and pensionary benefit, my lord. It was last listed 21/5/25, my lord.
18th.
Maybe let's item number 36.
Hmm.
I have instruction to withdraw the case with liberty,
36.
with liberty to file a press.
Why you want to withdraw it?
I have instruction from my client.
Why do you want to withdraw it?
I have instruction from my client.
Then why do you want to file it again?
Yeah, it's too.
If you want to withdraw it, why do you want to file it? Your name, please.
Suffered too long actually.
What is your name?
S. Burwa, Satyawat Burwa.
Mr. S. Borua, learned counsel for the petitioner, on instruction submits that the writ petitioner does not wish to press the petition any further. Accordingly, the same, and he would like to withdraw the same. The writ petition accordingly stands disposed of on withdrawal.
May I please, Your Lordship. Wait for listing admission matter next week and any date.
18th. Yes.
Yes, Lordship, mention for listing.
What matter? For what?
Co-warrantor matter.
Huh?
Co-warrantor matter.
Co-warrantor. Co-warrantor against what?
Post and positions. Post and positions.
I have not understood.
Post and position.
Forced imposition
Imposition.
of what?
Public officer.
Public office. In which department? It's a fresh matter.
No, pending matter.
Pending. 18th.
Obvious.
Yeah, please, Your Lordship. Your Lordship, I beg to mention for listing of the matter, Your Lordship. The petitioner is on the verge of, one of the petitioner is on the verge of retirement, Your Lordship.
18th August?
Lordship, Monday, 11.
No.
and
18th.
Lordship.
May it please your lordship, my lord, I'm praying for listing a writ petition, my lord. It was last listed on
20 August.
no,
In
like-
the paying for listing first.
20 August.
For withdrawal, item 72.
Makes sense. I may be allowed to withdraw this.
MS so-and-so, learned counsel for the petitioner, on instruction submits that the writ petition does not wish to press the petition any further and seeks to withdraw the same. Writ petition accordingly stands dismissed on withdrawal. Interim orders, if any, stand vacated. Pending ayes are also dismissed. Yes.
For motion, item 1.
Wait, please, Lordship. Well, section 11 petition, my lord, there is a
Notice,
dispute, my lord.
will issue notice at this stage?
My lord, your lordship may.
Heard Mr. E. Bora, Ram Bora. Senior counsel assisted by Mr. M. Saiwal. It's an application in section 11(6), praying for appointment of an arbitrator. Issue notice. Returnable 3 weeks. Steps on the respondent by registered post AD. Do you want to take Dusty also?
No, Lordship, no.
Registered post AD. Returnable after 3 weeks. Extra copies be furnished, sorry. Steps by registered post AD within 3 weeks.
Much obliged.
Item 3.
May I please, Your Lordship? My lord, this matter relates to transfer and release order, my lord. My lord, I am a duty officer working at All India Airport, my lord. And on, my lord, 18/6/2025.
Will issue notice at this stage?
My lord, till then, my lord, some interim prayer is there, my
No,
lord.
no, no.
Because after,
When were you transferred?
my lord, I have been, order has been given on 18/6/2025. And on the very day, my lord, I have filed my resignation letter, my lord. After getting my resignation letter, they have passed an order of transfer, my lord. And to immediately on, my lord, 21/6/2021,
Where is that?
release order has been given.
Where is that impugned order?
My lord, impugned order at page, my lord. 24, my lord.
And where is your resignation letter?
Resignation letter at page, my lord, 16.
Huh?
Page 16 and 19, my lord. One is by email and one is by handwriting, my lord. Page 16 is email, my lord.
So why are you concerned about the transfer order? You have already resigned.
Yes, my lord. I have been resigned, but they have give the transfer order, my lord. And release order also been given, my lord. But I am ready to serve the notice period of 3 months in the existing post of Guwahati, my lord. But they have transferred me to Raipur, my lord. I am in compelling circumstances that my mother is in ill health, my lord. He is bedridden patient of old age, my lord.
You submitted on 18/6
My lord, I have filed on 18/6, my lord.
and the transfer order is issued earlier.
My lord, it is shown prepare on 13/6/2025, but it was come into effect on 18/6/2025, my lord. Page 24. The signature of this transfer order was signed on 18/6/2025. But it is shown that this
No,
letter
who-
was prepared on 13 June, my lord.
Whose signature is this? 18/6?
My lord, this is the signature of, my lord, Airport Services Limited, my lord. This is Dr. Biplab Chatterjee, my
I
lord.
heard
Yes.
Mr. So-and-so, the counsel for petitioner. Petitioner, he is an employee under the air. What is Airport Services Limited? Is it the airport authority?
My lord, it is Deputy General Manager, my lord, Regional Insurance, AIASL, my lord.
Do you have your,
Respondent number 4, my lord.
do you have your appointment order?
My lord, my service ID is there, my lord.
Appointment order? Any appointment order?
My lord, appointment order is not annexed, my lord, but I am working, my lord, since 2021, my lord. The service ID card is annexed, my lord, as annexure 1 in page number 15, my lord.
Petitioner claims to be the duty officer. Claims petitioner submits that he is the duty officer of. What is AI?
All India Airport Authority, my lord.
AI Airport Services Limited. Which was formerly known as Air India Air Transport Services Limited. Stop. It is submitted that this the employer is a public sector undertaking. So petitioner submits that because of personal reasons, she submitted her resignation. By sending an email dated 18/6/2025 and followed by communication also dated 18/6/2025 addressed to the station in charge nodal officer AIASL Eastern Region LGBI Airport Guwahati. Stop. However, without accepting her resignation, the petitioner was served with the impugned transfer order dated 13 June 2025, which the petitioner claims was officially issued on 18/6/2025, immediately upon receipt of her resignation letters. Stop. It is submitted that the petitioner is willing to render her mandatory period of service required till the resignation is accepted. And however, the transfer order at this stage is totally uncalled for, as the petitioner has already filed the resignation. Stop. Being agreed, the present writ petition has been filed. Issue notice, returnable 4 weeks. Steps on the respondents by registered post AD as well as usual course. Is there any CGC? Copies in respect of respondent 1 may be served in the office of the DSGI Guwahati High Court. Stop. Matter be listed again on 22nd of August. Till the next date fixed, the impugned order of transfer dated so and so shall remain stay. Pendency of the writ petition will not be a bar for the authorities to proceed for acceptance of the resignation submitted by the writ petitioner.
Highly obliged.
Second, four,
Wait, please, Your Lordship.
Yes.
The petitioner in this case, Your Lordship, was appointed as a Sahayat. There was an advertisement, Your Lordship. As per the
Oh,
advertisement,
what happened? What happened?
The petitioner submitted a representation, my lords, that as reflected in my lordship's last order. The there's a report pursuant to the personal hearing. He could not produce the original, my lords.
You did not produce the original.
I was told that he could not find the original copy, Your Lordship.
Then what remains?
Your Lordship, in this case, my respectful submission, Your Lordship, is the certificate is a genuine certificate. Both the certificates that I have produced before the petitioner is genuine certificate. The only thing is, Your Lordship, one certificate does not contain this signed signature of the additional general.
No, you produced some certificate, photocopy
Yes, Your Lordship.
before the authorities.
Yes, Your Lordship.
Produce the original.
The original, Your Lordship, I am told he has not been able to find the original certificate, Your Lordship.
Then all consequential orders will follow. How do you retain a photocopy without having the original?
Yes, this is what I told him, Your Lordship. Unfortunately, he has not found the certificate. The original one. But my respectful submission, Your Lordship, is that in this case, Your Lordship, both the, Your Lordship may kindly peruse the certificates for a moment, as page 48 and 49. There are two experience certificate, Your Lordship. Page 48. This, may I read, Your Lordship? This certificate is signed by the subdivisional engineer, Agomoni Electrical Subdivision. And the other certificate also, Lordship, at page 49, is signed by the subdivisional engineer, Agomoni Electrical Subdivision, but it is countersigned by the assistant general manager, Dubri Electrical Division. The other certificate does not have this counter signature, which was required as per the advertisement, Your Lordship. I admit that it was an error on my part, Your Lordship, but I have worked for so many years, Your Lordship. They have not considered my case at that stage, Your Lordship. These certificates are genuine. They have also in their inquiry report. If Your Lordship may kindly peruse the inquiry report at page 108.
Who are we to decide whether a certificate is genuine or not? Is it attested
No,
by
Your Lordship, they have
gazetted
not made,
officer?
they had not made the inquiry in such a manner in my respectful submission
Huh?
to establish whether the certificate was genuine or not. In fact, they have stated that this is a genuine certificate. The only problem is with respect to the signature, Your Lordship. Signature of that assistant general manager. That was the
Is this
only
not
ground.
available in the records?
No, my lords.
It will not be available in the records.
It is
How
not
will it be available?
It's on the
This
actual.
is not an official communication. You wanted a certificate, they gave you a certificate.
Yes.
Either you or the authors of the certificate will have the original copy.
That is in my respectful submission needs to have been considered in the inquiry. That was not done in.
How will it be considered?
They could have called the SD, Your Lordship,
Huh?
divisional engineer, the assistant general manager. They have not done that, Your Lordship.
You are asking for something which is
No, Your Lordship, my respectful
beyond the
submission is-
permissible limits.
I have worked for such a long period
You
of time.
may have worked, that will be on a different consideration. But
Only-
the fact that you could not produce the certificate has to be ascertained.
I do agree. with
We'll give you some time to dwell over it. Come back next week.
Yes, Your Lordship.
List on 13th.
Till that the interim that is interim protection.
Some interim is there.
Yes,
There is an interim one.
All right,
No question.
interim order passed earlier will continue till the next.
These actions, my lords, otherwise.
As the standing council, standing council, Mr. B.
Chaudhary.
Chaudhary, if for a PTCL submits that the petitioner could not produce the original certificate in the hearing which was undertaken before by the
CGM HRM.
CGM
Chief General
HR.
Manager HR.
CGM HR.
HR.
CGM HR. So, copy of this instruction is also placed before the court. Stop learned counsel for the petitioner. Prays for a week's time to complete his instructions. Let the matter be listed on 13th. Interim order passed earlier will continue till the next date fixed.
Interim may be
I'm very
reconsidered
grateful.
on the next date, my lord. Please.
Only till next date.
No.
I'm very grateful.
MSU Sharma appears for respondent one.
Item 5.
Yes,
Yes, Your Honor, last time the question was that a minor who, at the time of death of his father, could not file his application, and when he became major, he filed his application, whether that should be considered or not. So I want to place some judgment, Your Honor. This. Your Lordship, a relevant paragraph is in paragraph, second page, that is paragraph 4. The Supreme Court in Soed Khadim Hussain versus State of Bihar and other reported in 2006 9 SCC while considering the rejection of the authorities for compassionate appointment, where the mother had earlier applied and taken view that the minor son who could not have applied earlier has a right to be given due consideration.
subsequent to that, there are other judgments of the Supreme.
Other judgment of, but subsequent judgment also followed this principle, Your Honor. I have another judgment also. Here,
Subsequent judgments of the Supreme Court.
yes. But this Honorable Guwahati High Court has followed this.
We are bound by coordinate bench's orders, but we are bound by orders passed by the Supreme Court. There are subsequent judgments on this issue. You address on this point. Yes, Mr. Bora.
Lordship, otherwise, coordinate bench judgment, my learned colleague actually on the last occasion, she placed the judgment, Ms. M. Bhattacharjee, the Tapan Soike judgment, perhaps it is on record, passed by very recently on the same issue. So the department as such cannot wait on for the petitioner to become a major as such.
The copy is there.
Copy was submitted last
Tapan Soike,
occasion.
give the particulars.
6916 of 23.
This judgment is of 2024 of the Honorable Guwahati High Court.
Tapan Soike judgment already. Yes.
Here, this view has been followed by this Honorable Guwahati High Court.
691623.
This is the.
When we ask you a query,
Yes.
you either come with a reply or you say, no, you don't have an answer. Don't skirt the question. We are asking you that there are judgments of the Supreme Court.
Yes.
Are you aware or not?
That is not.
You are not aware. So take time. We'll
This
give
is
you
the
time.
Tapan Soike judgment referred by this respondent authority. Here also, the
After 1 week. You come back after 1 week.
Yes.
Come prepared.
Item 6.
Right, with your lord.
Yes.
My lord, the petitioner was suspended 25 months back, my lord. No
Yes,
review.
instructions.
One instruction received, Lordship.
Huh?
Instruction not received, Lordship.
Which rules are applicable for you?
My lord,
Which rules are applicable?
6-2, my.
64.
But that is, are you a government servant?
Yes, I'm a lot mandal.
Lot Mandal.
Is he a government servant?
Yes,
Lordship.
Yes.
yes, my lord.
Gazetted.
Not this.
No.
What is your instruction?
Lordship, as per the instruction, no review has been done, but the departmental proceeding has already been completed. The inquiry has been. It is submitted to the government higher authority, Lordship, for obtaining approval on quantum of punishment, Lordship.
Bring it on record
Lordship.
My lord.
immediately.
Lordship.
My lord, the inquiry was completed and report was submitted last August, 1 year back. And your lordship knows that prolonged suspension plays the color of a punishment.
Therefore, we want it on record. Heard Mr. J. Patwari, counsel for the petitioner, Mr. S. Doctor, standing counsel, the Revenue Department, and MSU Sharma for Respondent number 2, Mr. Dr. Has received instruction, on instruction submits that the suspension was not reviewed and however, the departmental proceedings initiated against the charged official has already been completed, and the inquiry report has been submitted to the government in the Revenue and Disaster Management Department. Stop. Let the order of the disciplinary authority has not considered.
Not considered, Your Lordship.
Stop. Let this instruction be placed on record by way of an affidavit by the respondents. Matter be listed after 2 weeks on 27th August.
Lordship, issue notice, notice is not issued till that.
Already issued notice, returnable so and so. Mr. S. Doctor appears for Revenue Department. U. Sharma for respondent 2 is the DC.
DC, Lordship. We
DC.
have not received extra copies here.
Extra copies be furnished within the course of the day. The respondents, more particularly the Revenue Department, will file their affidavit, if so advised, within 2 weeks. Matter be listed on 27th.
27/8. Lordship.
Yes, yeah.
I think 7.
May I please, Your Lordship? Lordship, by way of this writ petition, I challenge the appointment of the private respondent. Lordship, here, a recruitment process was initiated for the post of assistant librarian in the GAD by advertisement dated 12/4/2023, which Your Lordship will find at page 23. And the relevant portion Your Lordship will find at page 24. This
That
was
page,
24. Lordship will see top B. This advertisement was for 2 posts. A is different. I am for B. B is the assistant librarian in the Directorate of Archives. And Lordship will see below B6. B6, educational qualifications. The candidate must possess a bachelor's degree from a university recognized by the government. Candidate must possess a diploma in library science from a recognized government institute. And preference will be given to candidates having the 3 years service experience in library science. Now, my contention before this honorable court is, while I possess the 3 qualifications given here, the candidate who has been appointed does not possess the qualification at serial number 2. In spite of that, she has been placed in the select list at number 1. So when the candidate does not have the requisite qualification, she could not have been considered, Lordship. Now, if the authorities can come up with something that she had the qualification, Lordship, I would not have any case, Lordship. But I received initially the information was not divulged, but yesterday I received a communication by RTI stating that she does not have a diploma in library science.
has it been altered subsequent
No,
to the advertisement?
no. So at this moment, Lordship, my only prayer would be let the notice go, let them respond, Lordship. because
Who's
they are-
for the APSC?
Okay.
Heard the counsel for parties. Issue notice. Returnable 4 weeks. Mr. A. Fukan appears for respondent number
1 and 2. 1 and
1
2.
and 2. Mr.
Sharma, my lord.
B. Sharma for respondent
3.
3. Since the standing councils represent respondents 1, 2, and 3, notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 4 by registered post AD as well as usual course within 1 week from today. List after the returnable date. 5th of September.
So nice.
Deeply aware.
5th of
Deeply.
September.
I can wait.
May please the lordship, the limited fair lordship, the for this was of the representation page lordship 21 lordship for direction to the respondent number 2. DC.
What direction you want?
The lordship, the this was of the representation.
Why should we issue a direction like that? We get instructions to find out what is the status here.
Your Lordship, otherwise also shouldn't have any ground for challenging this whole suspension order because he was given an opportunity. He filed a reply. If the
We
impugned
find
order.
out what is the status of the,
Yes, Your Lordship, well, fine.
The lordship, the first the focus
let
notice
him
on
get
7.
let him get the instructions. What
Lordship.
is the status of you? This was
Lordship.
filed on February,
Lordship.
may have been disposed of.
Lordship.
Heard counsel for parties, petitioner is has approached this court, being a challenge to the suspension order issued by the authorities. Stop petitioner was appointed as a counselor. Gaon Pradhan of charge number 2, Rupshi Moza, Bornagar Revenue Circle. In the district of Dhuri, Borpeta, Borpeta, in the district of Borpeta. Based on certain allegations made against the complaints against the petitioner, he was placed under suspension. Stop petitioner has preferred a representation before the Deputy Commission, District Commissioner Borpeta, dated 4/2/2025, which has not been disposed of. His limited prayer is that a direction be issued to dispose of the said representations. Mr. D. Bora, learned government advocate, will obtain instructions from the respondent number 2 as to the status of the representation stated to have been filed by the petitioner. Let these instructions be placed before the court on 18th.
20th, Your Lordship. 20.
20.
No further order.
No, 18th. Just instruction as to what is the status.
I'll not be available on 18th, Your Lordship.
Huh?
I'll not be available on 18th.
Then have it on 13th?
13th,
Yes,
13th, Your Lordship.
13th.
Lordship, no further order was passed by the
Extra copy may be furnished.
You furnish an extra copy
Yes.
within the course of the day.
Lordship. Diploma.
Until 9.
May I please, Lordship?
Yes.
Lordship, the petitioner is not getting her pensionary benefit, including gratuity and leave encashment.
My lord, let notice go. I'm appearing for respondent 1 here, man.
Heard counsel for parties issued notice. Returnable 4 weeks. Mr. Radhor appears for 1 and 2.
My lord,
Only one.
respondent number 1, man.
Only one.
1, man, at this moment.
Steps on respondent 2, 3, 4 by registered post AD as well as usual course within 1 week from today. Since respondent 1 is represented by Mr. Thor, notices are waived, extra copies we furnished within 1 week from today.
I can give.
Petitioner was placed under suspension in view of his arrest on 16/6/2023, Lordship. Since then, no review has been made. Lordship.
Notice, my lord.
Heard counsel for parties issue notice. returnable 4 weeks, 3 weeks. Mr. Ardor, yes, for us, all 1, 2, and 3. MSU Sharma for responding 4. Since notices are, respondents are represented, notices are waived, extra copies will be furnished within the period of 1 week from today. Let the respondents complete their instructions and apprise the court as to whether the suspension of the continued suspension of the petition was reviewed as required under law.
May I pray for a date, Lordship?
List on 27th
August.
August.
Public scripture.
That is 11.
My lord, in this case, the petitioner is demoted from the post of ST engineer to the post of junior engineer, and that my lord, as a fishery development corporation. And the similar matter, lordship has issued the notice, my lord. Only lordship may examine that
After an inquiry,
after inquiry, yes. Lordship has fixed the other matters. This is one of the matters.
both are pertaining to the same department.
Same office, same.
Heard. Senate Council for Parties issue notice. Returnable 4 weeks. Mr. P. Sharma appears for all the respondents. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. You are appearing for number 4 also.
Yes, lordship.
All right. The respondents may complete their instructions and file necessary affidavit in the matter list. You want both the matters to be listed together?
Yes.
It is submitted by the counsel for the petitioner that this matter be listed along with WPC 2962 of 2025 as a similarly situated person has also approached this court earlier and filed the writ petition. Accordingly, let both the matters be listed together after the returnable date, on the returnable date.
Item 12.
My lord, order dated 5/5/25, my lord, placing me in suspension at page 82. These are the challenge here, my lord.
Page number
Page 82, my lord.
82.
My lord, on the face of it, either suspension or simpliciter, my lord, the ground is narrated at para 2, my lord. Whereas in the written statement dated so and so of Sri Vishnu Jyoti Dole, a student of so and so college and hospital, was involved in adopting unfair means, including using a mobile phone in the examination hall on 23/7/24, has mentioned that Dr. Deep Kumar Medi had accepted by Deep Kumar Medi is myself from him for allowing to adopt unfair means. Actually, my lord, he was the principal in charge of the college and also the supervisor, so far as the examination is concerned. And there were appointed center in charge, examination center in charge, and also invigilator. Now the CCTV footage showed the invigilator as having allowed the student, my lord, to use the mobile phone. And also taking it back after the first half, and then again making it available to the student in the second half. And that was inspected by the registrar of the controlling university and also the director of the.
Petitioner was not the invigilator.
I was not, my lord. I was not even the examination center in charge. I am the principal, my lord. By virtue of that office, I am the supervisor. And I had seen it and I caught the person red-handed, my lord. And what happened, my lord? More than that, my lord, on the statement of that student, my lord, I was suspended. But before that suspension occurred, my lord, I asked for opportunities by 2 representatives that I have annexed, my lord. I even filed a case with the Special Superintendent of Police, CID, my lord. In spite of that, they suspended. In my humble submission, man, at least, my lord, I was entitled to a show cause or an explanation, my lord, which I could have given, man. And I had gone to the disciplinary proceedings against that particular invigilator. as a PW minor. In that minor, this thing has happened where the student said that he had paid 50,000 for allowing him to copy in the sick room. But whereas all these things are controlled under me by the examination center in charge and the invigilator. And the CCTV footage clearly showed that it was the invigilator who made available the mobile phone man.
You're right, we'll issue notice at this stage.
Minor.
No, when was he suspended?
5 minor. 25 this year.
Heard learned counsel, Mr. B.D. Goswami, learned counsel petitioner, and Mr. M. Via, learned counsel appearing for respondents 1, 2, 3, and 4.
Yes, Lordship, 3 and 4 is.
Steps on Mr. M.S.U. Sharma for respondent number 9. Steps on respondents 5, 6, 7, 8 by registered post, AD as well as usual course within 1 week from today. Since the respondents 1, 2, 3, 4, and 9 are represented by the council, government council, notices are waived, however extra copies be furnished within 1 week from today. Any proceedings which may be initiated? The continuance of the suspension will be subject to the outcome of the writ petition.
Your Lordship has made the notice returnable by
4 weeks.
Much obliged, Lordship.
Item 30.
Wait, PJ Lordship.
Well, this is the third round of litigation, my lord. Now, if your lordships would kindly come to the order of these coordinate bench at page 56, my lord. Page 56, para 16.
Yes.
For the reasons stated herein above, this court is of the opinion that the impugned order of dismissal from service dated 14/12/23 is vitiated by arbitrariness and illegality. The same is accordingly set aside. Consequently, writ petitioner shall be reinstated back in service forthwith. However, having regard to the peculiar facts and circumstances of the case and nature of allegation brought against the petitioner, this court is of the opinion that the fact of the case do not justify exoneration of the petitioner on such technical ground without subjecting him to a proper inquiry proceeding. As such, the department is granted liberty to initiate fresh proceeding against the petitioner from the stage of issuing notice upon the petitioner to explain his conduct. Now, this is important, my lord. If such explanation to be furnished by the writ petitioner is found to be unsatisfactory, it will be open for the disciplinary authority to draw up disciplinary proceeding against him as per law. Since the petitioner is due for retirement from service with effect from February 26, it is made clear that whatever proceeding is to be initiated against the petitioner by disciplinary authority, same shall be concluded within a period of 6 months with effect from so-and-so. Now, para 18, in case of so-and-so, the issue was pertaining to vagueness of charge. However, this court has granted liberty to the disciplinary authority to initiate a fresh process by serving notice upon the petitioner to explain his conduct, and if the same is found to be unsatisfactory, then only departmental proceeding will be initiated. Actually, what had happened, my lord, earlier, my lord, when the petitioner was in Nalbari, an inquiry was conducted by the deputy commissioner. Based on that, my lord, the earlier proceedings were conducted. That is why this honorable court interfered with the order, directed his reinstatement, however, giving liberty to the department to proceed against him from the stage of issuing show cause notice. Now, my lord, the requirement is first they will issue an explanation, will submit the reply, then they will have to record their satisfaction that yes, it's a case where there should be a disciplinary proceeding. So this is a mandate follows from this order. Now, my lord, they issued a show cause notice again that your lordships will get at page number 59.
without, my lord, complying with the direction in this judgment, then, my lord, the government themselves, there was an order, there is an order at page 64, my lord. In respect of the second show cause, P.N. Goswami, learned AAG.
No, just one
Yes.
meaning. Para 16, the last line,
Yes, my lord. 1 second.
initiate fresh proceedings.
Yes,
From the stage of issuing notice means the what? The
show cause notice.
show cause, fresh show cause.
Fresh show cause.
Fresh show cause.
Yes. And there is a rider, my lord.
Ah.
Before issuing show cause notice, an explanation will be called for. The petitioner is supposed to give you the reply. Then, based on the reply, the disciplinary authority will have to draw satisfaction that yes, we are not satisfied with the reply. So it's a case which calls for a DP. Then a show cause notice can be issued. In my humble understanding, that is the purport of this order. Then, my lords, a second show cause notice was issued at page 59. We challenged this because that requirement was not followed. Then eventually they themselves withdrew the show cause notice, my lord.
We challenged it before the High Court again.
Yes, yes. At page number 61 is the order, 63 is the order of the High Court, my lord. 3475. Then kindly
Then
see
it
at
was
page
cancelled.
64, the Additional Advocate General Goswami appeared and he said that the show cause notice has been withdrawn. Now, my lord, by resorting to the same modus operandi, now another show cause notice has been issued, which your lordships will get at page number 71. So eventually we are going back to the first show cause notice dated 13/6/22. Now nowhere there is a recital that the explanation submitted by you is examined. We do not find any merit. We are satisfied you are guilty of prima facie guilty of misconduct. Therefore, we have decided to proceed departmentally against you. Now again a show cause notice has been issued.
Yes,
My lord will kindly peruse page 66.
6-6.
66.
Like this.
It connects with the page number 56, para 16.
66 or 56?
66, annexure 9. It's a call for explanation.
Ah.
So, my lord, these connects with the paragraph 16 of the judgment, my lord, the page 56. There's a call for explanation. Yes. Perhaps the case of the petitioner is there. What I could understand, my lord, while issuing this show cause, the purported show cause, impugn show cause at page 71, there is no whisper of this letter at page 66.
No, page 66
Call for explanation, my lord.
66, when was it issued? 27-6.
27-6. And my lord, he had replied at page 67. Now the petitioner's case, what I could understand, my lord, at page 71, while passing this show cause, there was no whisper of his reply, whether it's accepted, whether it was.
That's right. That
Yes.
is his case.
So if that be the case, my lord, I'll, lordship it may allow, my lord, then we'll issue a fresh show cause. My lord, we'll take into account his reply.
For you to decide.
Yes.
There is a categorical fight.
Yes, that will do, my lords. Lordship will allow this petition up to that extent, my lords. Then we'll take a fresh call, we'll issue fresh, and we'll consider his reply, and we'll indicate whether we have accepted his
Mr.
side of the
Joy,
story or not.
Paragraph 16 at page 56 is very clear.
Yes, my lords.
Why do you want a reiteration of the same order?
No, my lords, I'm saying my lord will not reiterate that. My lords will allow this petition, but just grant us the liberty. Para 60.
That has already been done.
Yes,
Why should we grant you further liberty?
my lords.
Means
Then
for
Indian-
you want to recall that notification, you do it.
Yes, my lords. We'll
But
recall this. We'll
If we
recall
have to
this.
set it aside.
Yes,
We will have to decide whether we grant you further liberty or not.
my lords.
Why should we grant you liberty again and again?
No, my lords, some procedural lapse has occurred because, my lords,
So you set it right.
my lords.
Where's the bar?
And then
If you-
my lord
if
will
you-
list
if-
it, my
if
lord will list it in after 7 days, we'll be issuing a fresh one. Which will indicate whether we have accepted his reply or not. Perhaps this is his case, nothing
Till
else.
then, my lord, this lordship will stay this, yes.
Mr. K. N. Chaudhary, learned the counsel assisted by Mr. P. N. Acharya. Counsel for the petitioner. Mr. D. Gugoi appearing for all.
My lords.
Yes. I
Yes.
think-
Appearing for all.
My lord, yes.
For all the respondents.
Yes, yes.
Petitioner
123.
is before this court putting a challenge to the show cause dated 3007/2025, calling upon him to show cause as to why penalty under the provisions of the Act should not be imposed. Stop. The learned senior counsel submits that earlier on a show cause being issued, the petitioner has approached this court by filing WPC number 2211, which came to be disposed of by judgment and order dated 27/2/2025. And in the said judgment, the coordinate bench interfered with the show cause notice issued. However, granting liberty to the department to initiate fresh proceedings against the petitioner from the stage of issuing notice upon the petitioner to explain his conduct, and further held that if such an explanation is furnished and is found to be unsatisfactory, it will be open to the departmental authority, disciplinary authority, to draw up proceedings against law, as per law. And since the petitioner is due to retire in February 2026, it was also directed that whatever proceedings are initiated by the departmental authority, the same shall be concluded within a period of 6 months, with effect from 1/3/2025. Stop. Pursuant thereto, the department issued a show cause notice dated 23/5/2025, which again came to be assailed before this court by filing WPC 3475 of 2025 on the ground that the said show cause notice is issued in violation of the judgment and order dated so and so passed in WPC 2211 of 2024. Stop. Pursuant to the second writ petition being filed, the respondents withdrew the earlier earlier show cause notice by cancelling the same by the order dated 25/6/2025, and consequently the writ petition WPC 3475 of 2025 came to be closed, granting liberty to the petitioner to file. Granting liberty to the department. Stop. Pursuant thereto, the petitioner was served with communication dated 27/6/2025, calling upon him for explanation. Stop. In pursuance to the said explanation letter, the petitioner submitted his reply dated 3/7/2025. Stop. However, it is the submission of the senior counsel for the petitioner that, however, without consideration of his explanation and as directed by the court by the judgment and order dated 27/2/2025 passed in 2211 of 2024, the show cause notice, impugned show cause notice dated 3007/2025 came to be issued. Stop. It is submitted that this process followed by the department is contrary to the specific directions issued by the coordinate bench by this court in the judgment and order dated so and so passed in WPC so and so. He therefore submits that the respondents be directed to comply with the directions contained in the order dated so and so before proceeding to issue the impugned show cause dated so and so. Stop. Mr. D. Uvoy, standing counsel for the respondents. on instruction submits that the matter be called up,
After.
he be permitted to complete his instructions and be granted a week's time. Stop. His prayer is not objected to by the senior counsel. However, who submits that the proceedings initiated by the impugned show cause notice should be stayed till the next returnable date. Para. Under such circumstances, we permit Mr. Gogoi to complete his instructions and direct that the matter be listed again on
After 7 day, after 10 days, man, as fixed date,
27th
27.
of August, by which date the respondents will apprise the court as to the course of action they desire to follow. Stop. Till the next date fixed, till the next returnable date, which is 27th of August, impugned show cause notice and all proceedings thereunder shall remain stayed. The counsel for the petitioner on record will ensure service of extra copies on the respondent within the course of the day.
All right.
Title 14,
My lord, petitioner's husband was serving under Assam Plains Type Development Corporation, who died on 19/1/2022.
We will issue notice.
Yes, madam.
What else? Third counsel for parties issue notice in about 4 weeks. Mr. K. Kolita.
3 and 4.
For respondents, 3 and 4.
3 and 4.
Mr. R. Dhor appears for respondent 1, 2,
5 and 6.
5 and 6. Mr. Arbor Pujari for 7. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. Respondents may complete their instructions and file necessary affidavit.
List along with 4353.
When is it least? When is it fixed?
8 September.
8th of September. It is submitted that a similar matter is pending and the matter be directed to be listed along with WPC number
4353 of 2025.
4353 of 2025, which is fixed on 8th. List this matter accordingly. Extra copies within 1 week. Extra copies within
Yes.
1 week. Yes.
Next matter is also similar.
Huh?
Next matter is also
Next
similar.
matter similar, same date, same order.
supplementary list for motion item 68.
Wait, please, my lord. My lord, additionally, Mr. B. Gogo is appearing in this matter, my lord. Can it be after some time, my lord?
Yes,
Just request your lordship, if a time can be fixed, because I have a slight difficulty after lunch today. If it is, can be around 12:30, if it is not inconvenience.
Yes, my
Then we
lord.
could
you
try.
call him
Yes,
Yes,
my lord.
maybe.
as early as
After some-
possible.
After some time.
Great.
All right.
69.
Yes.
My lord, I'm the one of the senior most, the pediatrician and the head of the department, my lord, in the professor of Assam Medical College, my lord. What happened in this case, my lord? A complaint has been initiated against me by one lady for harassment in the sexual harassment in the workplace, my lord. Then lordship will kindly see that complaint that as per the procedure, my lord, section 4 of the act itself, the sexual harassment in workplaces, my lord. That lordship will find if at page, my lord, the initial page 26, my lord.
You're referring to the act,
No, my lord, page 26 of my petition, my lord.
26, okay.
Yes, to the professor, head of the department, pediatrics, so-and-so, later dated so-and-so, on, that is on 18th October 2022. You are requested to appear before the IC, that's the internal committee as per the Visakha judgment, my lord. AMC today, that is on 18 itself, at 1 PM, the college council room. That is the first, and the subject is also letter number dated
22, my lord, dated 17/10/22. So there is a complaint has been initiated, my lord. And the next, my lord, page Annex 3, page 28, my lord, as you kindly see. Accordingly, my lord, on receipt of the complaint, my lord, to the principal superintendent, my lord, on receipt of the complaint dated 17/10/22, the internal committee, after duly hearing the PGT student and HOD of the Department of Pediatrics, Pranoy Day, along with the audio recording submitted in a pen drive, the call logs of the audio recording has been requested and are submitted by the students. The committee is of the unanimous opinion that the action of the Pranoy Day constituted an harassment and the stalking of the PG student who is since suffering from a panic anxiety attack, and the other PGT students are apprehension of the visited environment, which warrant the HOD should be no longer remain in the campus or attend his duties. So the inquiry proceeding can be conducted in the conducive environment without basis or coercion from the HOD Pranoy Day. Up to that is no problem, my lord. That's the requirement of the act itself. So as per the Annex 2, my lord, page 27, accordingly, my lord, in the interest of the public service, I have been transferred, my lord, the second paragraph from Dibrugarh to Silchar, my lord, in the same post, my lord. Now what happened, my lord, subsequent to up to there is no problem, my lord. Then, my lord, Annex 6, my lord. Now, Lordship knows, my lord, these kind of offences, if there is an allegation, it is solely the complaint committee. They have to decide accordingly, as per the requirement of the judgments, my lord. The authority can't do anything, my lord. It is the complaint committee, they have to take the call. And final report on the basis of the final decision of the complaint committee, then the authority can act it upon. Not before that, my lord. But where, on the basis of that first order from transfer me, they have initiated a proceeding. So moto they have taken up the bypassing the complaint committee, my lord. The parallel.
What happened to the findings of the ICC?
Nothing. That remained, my lord.
It's still going on.
Yes. They have hijacked it and they have parallelly started one more proceeding, departmental proceeding. And then thereafter, there is a finding, and accordingly I have been demoted, my lord. It can't be, my lord. There cannot be any parallel proceeding where there is a IC committee is still pending. There is a judgment of 2 days. There is Supreme Court 2 judgment subsequent to the Vishaka judgment.
Yes.
My lord,
This is a state government employee.
Yes,
my lord.
So accordingly, my lord, I have been, my lord, and the impugn order is page, my lord.
Page 57, my lord.
Page 57, my lord. So the operative portion is page 58, my lord.
Yes.
Thereof the government of Assam pleased to impose the penalty of reduction of the lower post, associate professor under the so-and-so, Assam subject disciplinary rules, the pronounce so-and-so, Kokrajhar Medical College, hereby posted as the so-and-so. So now, Lordship, my lord, Lordship, kindly see the judgment, paragraph 44. The requirement of
Kotwal.
yes, Meda Kotwal, yes, Lordship is correct. Para 44.
Subsequent thereto, there's another.
Yes, there is a subsequent, my lord, there is a one more judgment, my lord.
From Goa.
Fernandez. Paragraph 75. Fernandez. Kotwal is 44, then the Fernandez is 75.
8397 it starts.
Yes.
Para 44, 44.1.
At page 309, my lord. 44.1, my lord.
Yes.
The state and the union territories which have not yet carried out the adequate and appropriate amendments in the respective civil services conduct rules by whatever names by the rules are called shall do so within 2 months from today by providing that the reports of the complaint committee shall be deemed to be an inquiry report in a disciplinary action under such civil services conduct rules. In other words, the disciplinary authority shall treat the report and finding, etc., of the complaint committee as the finding in a disciplinary inquiry against the delinquent employee and shall act upon the such report accordingly. So it's the sole jurisdiction is upon the complaint committee.
Yes. I think the subsequent judgment is more
Yes.
elaborate.
Yes, it's more elaborate, page 75, my lord. It starts from
Just as immaculate.
32.
632.
Page para 75 is the, they have discussed everything, my lord. Mera Katwal's page, paragraph 54, my lord.
Yes, what do you say?
My lord, the show cause notice was issued on 2/5/2024, my lord.
First thing you tell us whether the procedure laid down under law has been followed. That ICC committee has concluded the inquiry.
That instruction I have to obtain, my lord, because
That is the crucial instruction.
yes, my lord. Because, my lord, otherwise, my lord, section 13 of the act, my lord, says that, my lord, to take where the internal committee or the local committee, as the case may be, arrives at the conclusion that the
Now
allegation.
that you get your instructions, heard
Yes.
Mr. Anshuman Bora, Learned Senior Counsel, Assistant Mr. Jyotikman Pari, counsels for the petitioner, and Mr. B.P. Bora, Learned Standing Counsel. Hearing for all,
Yes.
No private.
Yes, my lord, all the respondents.
the petitioner before this court is a medical professional employed under the state health department as
Professor of
as a professor and HOD,
Professor in HOD.
Yes, pediatrics.
pediatrics,
Posted at Pokrajhar Medical.
presently posted at Kokrajhar Medical College. Stop. Pursuant to a complaint lodged against him under the sexual harassment at workplaces,
Prevention of Prohibition, Redressal Act 2013.
2013, by one student,
My,
by a student. The petition, the proceedings under the internal complaints committee was initiated, and the petitioner was asked to appear before the complaints committee. Stop. During the pendency of the proceedings, in order to ensure the proper inquiry be conducted against the petitioner, he was transferred out and posted in Silchar. Silchar.
And that relevant point.
Learned Senior Counsel submits, however, that although the inquiry was initiated by the internal complaints committee as constituted under the law, the proceedings have not yet been concluded, or if concluded, not in the findings thereof have not been intimated to the petitioner. Stop. However, the petitioner was surprised to be served upon a charge sheet by order dated by charge sheet dated 2/5/2024, calling upon the petitioner to reply to the charges leveled against the petitioner in the charge sheet, and as to why the penalties prescribed under Rule 7 of the so-and-so rules 1964 should not be imposed. Stop. The petitioner replied to the charges leveled against him. And subsequently, the inquiry was conducted against the petitioner purportedly on the same charges, which are or were currently being inquired into by the ICC on the basis of the complaints lodged against the petitioner. Stop. The findings in the inquiry the inquiry report concluded that there is a substance of truth in the allegations against the petitioner for having inflicted sexual harassment upon the complainant. And therefore, the charges of gross misconduct amounting to moral turpitude and violation of Rule 3(1) of the Assam Civil Service within bracket Conduct Rules 1965 have been established. Stop. Pursuant thereto, the disciplinary authority by order dated 24/7/2025 imposed the punishment on the petitioner by imposing a penalty of reduction to a lower post, that is associate professor, under the provisions of Rule 7 within bracket Roman 4 of the Assam Discipline and Appeal Rules 1964 on the petitioner. Stop. Learned counsel, senior counsel for the petitioner, submits that the procedure adopted by the respondents while resorting to the proceedings under Rule 7 of the Discipline and Appeal Rules and imposition of the penalty is totally contrary to the law laid down, totally contrary to the provisions of the so-and-so act read with the rules. Is there a state rules also?
No, madam, probably no.
No.
The central government already incorporated that, madam, but the
As well as to the judgment rendered in Medha Kotwal Lele versus so-and-so, reported in 2013 1 SCC 297, and Aureliano Fernandez reported in 2024 1 SCC 632. Referring to the said judgments rendered by the Apex Court, the learned senior counsel submits that the law has been authoritatively laid down by the Apex Court to the effect that any proceedings pursuant to any complaints lodged under the so-and-so act, it is the ICC committee who has to initiate the inquiry upon giving proper notice to the petitioners or to the charged official, and upon such findings arrived at by the committee holding the delinquent officer to be guilty of the charges of sexual harassment, the disciplinary authority may proceed to impose further penalties under the discipline and appeal rules on the basis of such findings arrived at by the internal complaints committee. Stop. This has been categorically held to be the procedure required to be followed by the authorities concerned in the judgments referred to. Stop. Learned senior counsel therefore submits that this procedure has been given a complete, has been totally ignored, and while the inquiry under the ICC is still pending, the authorities have proceeded unilaterally to impose the punishment on the petitioner by resorting to the process by taking recourse to Rule 7 of the Discipline and Appeal Rules and so and so. Therefore, he submits that the entire procedure resorted to by the department and concluding in the punishments imposed is totally contrary to the provisions of the law as well as to the law judgments of the Apex Court, and therefore the same needs to be interfered with, set aside and quashed. Para, Mr. Bora, Learned Standing Counsel on the other end, submits that at this stage he does not have any instructions with regard to the status of the inquiry completed or conducted under the ICC, by the ICC. He therefore seeks liberty to complete his instructions. Bera, considering the submissions made at the bar and upon perusal of the pleadings available in the writ petition and the law referred to by the laws and the judgments of the apex court referred to, this court is of the view that the matter will require hearing and due consideration by the court. Accordingly, let notice issue returnable 4 weeks. Since Mr. Bora appears.
May I submit one thing? My lord, regarding this instruction, I may produce it the day after tomorrow, my lord. Thereafter, your lordship may, whether the proceeding before the internal complaint committee is pending or it has been concluded.
That's very clear from the page 57.
The day after tomorrow, I will produce that instruction, my lord. Then your lordship
I've
may
been
pass necessary order.
already
my
asked
lord.
to join in the DFU, my lord. If I
It's a
join and
matter of-
everything, they may take another
I will
steps,
obtain
my
the
lord.
instruction and I will furnish it by day after tomorrow, my lord. Only that instruction, my lord.
Well,
If that
based
is so,
your-
my lord, if it is the pending, my lord, then your lordship may. But if it has
Even
been,
if it is complete,
Yes, my
then
lord.
you'll have to ensure that copies are served, the matter is placed before the authority.
The
authority
preliminary
consider-
instruction I can produce, my lord, the day after tomorrow, my lord.
Till then, my lord, I may be protected because I have
Day
been
after
directed.
tomorrow, only 2 days, my lord.
I have been directed.
Mr. Bora submits that these instructions, he can produce it within 2 days.
Yes, my lord, day after.
Therefore, let the matter be listed again
Till then, my lord.
on Monday.
Or Friday or itself I can produce. I can obtain the instruction, my lord, regarding the.
Let it be on Monday,
Yes, my lord.
on Monday 11th.
Yes, my lord.
The,
Monday. Well, I may not be available Monday, my lord.
you're not available,
Yes, my lord.
then your
Next.
counsel, your assisting counsel will be available. Or Wednesday? You're not available for the week.
I'm available only for the Monday. I have some.
Then we'll have it on Wednesday, 13th. Matter be listed on 13th. And till the next date fixed, the impugned order dated so and so, to the extent that the petitioner has been posted as Associate Professor, Department of Pediatrics, Tifu Medical College and Hospital, with immediate effect shall remain state.
Oblige, highly obliged.
Only to that extent.
Yes, sir. That will do, my lord. Oblige.
Obligement.
You furnish Mr. Patwari extra copies during the course of the day.
Yes, yes.
Obliged.
You have to will take back those books.
Huh?
We'll take back those bundles from it.
Of course.
That is new deal.
Please, Your Honor. Your Honor, we have already received instruction from the client that they doesn't want to pursue the matter. They have
Right.
sorted them.
Learned counsel for the petitioner. Petitioner has been, counsel for petitioner has received instructions from the writ petitioner, from the petitioner that the order has been complied with.
Yes, yes.
That the directions contained in the judgment and order dated so and so has since been complied with, and therefore the petitioner does not wish to proceed any further in the contempt proceedings. Do you have any document to
Yes,
say?
Your Honor.
The counsel for the respondent on instructions has also placed
Actually, it's an office. This office order, yes.
a copy of the office order.
But the name of, Lordship, the name of the contaminants figure at serial number 19 and 13.
19
And 13 on the next.
19 and 13.
Yes.
19 and
13, 1, 3.
1, 3.
Yes. Your Honor, there are different categories in the second page you mentioned.
19 and 13.
Yes, Your Honor, I have marked it to the stand.
Oh, okay, okay. In the second page.
Yes, Your Honor. They have been given the enhanced pay.
The counsel for the respondent also on instructions has submitted that the petitioners whose names appears at serial number 13 and 19 in the communication dated 26 5
Yes.
2025 in the office order dated 26/5/2025 issued by the Chief Executive Officer, Nagaon Electrical Circle, shows the names of the petitioner at serial number 13 and 19 in the column within bracket in the column in italics equal to or more than 10 years. Stop. He submits that the petitioners have been granted the enhanced pay as directed by the court. Copy of this instruction has also been placed before the court, taking into consideration the submission is made. The contempt petition stands closed. Notices issued stand withdrawn.
Item 17 and 18.
On behalf of respondent number 2, affidavit has been filed, my lord. On behalf of respondent number 2, affidavit has been filed, my lord. So it will be, already copy has been served, my lord. During the course of the day, it will be filed, my lord. Let it come on record.
Heard MS
A Pujari for item number 18, Lordship.
A. Pujari for item.
18, 17 says in lakes on 7, court number 6.
Affidavit was here, my lord.
You are filing in both.
Both.
Both
Already
cases.
copy has been served, my lord.
Right. In item number 18, Mr. S. Bora, counsel appearing for respondent.
Number 2.
2 submits that the affidavit will copies of the affidavit proposed to be filed have already been served on the counsel for the petitioner, and the affidavit will be filed during the course of the day.
I am appearing for both, my lord, 1 and 2. One has limited the whisk, my lord.
All right.
In the minute.
Let he therefore submits that the matters be listed after 1 week.
Lordship, date may be given.
Or you want it after 2 weeks?
Yeah.
Yes, be listed after 2 weeks. Let the matters be listed again on 27 August. The registry will ensure the affidavits stated. If any affidavit is filed by the respondent number 2, the registry will ensure that the same is connected to the case records by the next date.
Not problem.
Item 19.
The matter was considered and the order was passed. Just given a copy.
Lordship, I have no knowledge. Just
You go through it. Counsel for the respondent submits that the directions contained in the order dated so and so has been complied with and a speaking order has been passed. He has placed a copy of the same order before the court and has also served a copy to the counsel for the petitioner. Stop counsel for the petitioner therefore submits the matter be listed after 2 weeks, enabling her to complete her instructions on this. List again on 27th.
no.
Yes. Right.
It's a-
20.
Here the compliance order, draft copy is ready, my lord. And since new incumbent has joined as a commissioner, my lord, so it is taking time. Lord, she will post it after a week, my lord. In the meantime, it will be done, my lord.
Mr. S. Bora, standing counsel, counsel for the respondent number for the respondent submits that the further week's time be granted, by which time the directions contained in the order dated so and so, passed in WPC so and so will be complied with. Mr. S. Mukhtar, appearing for the petitioner, does not object to the prayer made. List this matter again on 22nd.
My lord.
Item 21.
You've taken fresh steps?
Steps already taken,
You were permitted to take fresh steps on 8/5.
Yes. my
After
lord.
that, have you taken
Yes.
steps?
My lord, 15/5/2025.
You have taken steps.
Yes, my lord. This is
It's
the.
not reflected here.
This is the.
Pursuant to the, in deference to the order dated 8/5/2025, counsel for the petitioner submits that fresh steps have been taken on
15/5/2020.
15/5/2025. Notices were issued as per office note dated 2/8/2025. AD card service on respondent 1 and 2 is awaited. It's awaited.
Yes.
List after 2 weeks.
Minute. A date may be given, my lord.
27.
27. Obviously.
Item 22.
May I please, your lordships? Your lordship order is that as page 13, start from direction part, page 15. Regarding minimum pay scale, lordships.
Where is the direction?
Direction, page 15, paragraph 4, lordships.
Yes.
This is related to minimum pay scale of lordship to the petitioners, and similar situation already getting 2019. That time I-9 forwarded, but incidentally they committed a mistake on the date of birth.
Yes.
Instruction is awaited, lordship. Also, the sole respondent has been transferred in the month of June, lordship. So,
This order, when was it passed?
Order passed on
2/2/2024.
24.
You're in contempt.
lord,
Do you want to go to jail?
some
Then?
more time.
Huh?
Sir, short time will leave, lordship.
Wait, 1 year, more than 1 year has passed. Why this order has not been complied with?
We have communicated, lordship, some more time.
We are giving you 3 weeks time, comply this order or file an appeal. Heard counsel for parties, the respondent counsel seeks further liberty, further time to obtain instructions as to whether the impugned order, the order passed in, order dated 2/2/2024 passed in WPC so and so has been complied with. Stop. Considering the prayer, matter is directed to be listed after 3 weeks, by which time it is expected that the directions contained in the order passed in WPC so and so should be complied with.
List on. Paying for fixing a date, lordship.
29th.
29. Obliged.
23.
Service report awaited.
Lordship, I appear
On
for
respondent
number
two.
1. 2, your lordship, I'm not appearing. I appear for 1.
Let he is the
Heard
main
Mr. M. Khan,
person.
Mr. G. Bordoloi for respondent 1. Office note dated 2/8/2024 reflects service on respondent 2 is awaited.
My lord, so far respondent number 1 is concerned, he is the main person.
Huh.
So for provisional pension is concerned, that is to be released. That amount has also not been released.
Yes.
Lordship, the latest instruction which I have received today morning is that his pension papers has been uploaded online and certain documents with regard to his pay fixations are available with the petitioner. Now he has been given notice by the office and he is supposed to bring the documents today or tomorrow and it will be done, your lordship.
So correct, provisional pension that can be released.
Why? When the final pension can be released?
Yes,
You
yes.
can approach the office.
That what direction,
Furnish whatever documents are
that
necessary.
direction was that till finalization of the pension, his provisional pension may be released. And if they are going to finalize, no, sir, I am not on.
So you get your instructions and
Well,
find it. Pay with service report, returnable matter be listed after 2 weeks. Meanwhile, you inform the petitioner after 2 weeks.
Obliged.
24.
Lordship, I am appear on behalf of the bank.
I cannot hear you, sorry.
Lordship, I appear on the behalf of the bank. Actually, we could not file the affidavit due to some personal reasons, and our engaged counsel is out of station. So kindly grant a short adjournment.
Lots of 1 week time may be granted, lordship, because there is an urgency. The petitioner was working in the bank for 13 years continuously. Now his service has been handed over a private
See,
bank.
today you are appearing on this side, you are asking for 1 week.
Yeah.
On the other side, you ask for 4 weeks.
I'm sorry, lordship. My learned friend also.
We'll
asked for
not give
1
them
week
4
time.
weeks, we'll give them 2 weeks.
Lordship.
I'd like to.
Yes, the counsel for respondent, please for further time. Further 2 weeks be granted.
May I pay for fixing a date, lordship?
Complete the instructions, list this matter on 29th
Lordship.
of August.
Obliged.
That is 25 and 26.
May I plead your lordship? Lordship, in this, I am appearing for respondent number 6 to 23. Lordship, I need 3 weeks time to file our objection also.
IA for what?
I for impleadment.
Impleadment. You're objecting to impleadment.
Yes, lordship.
In fact, my lord, there is a stay order, my lord. With regard to stay of the recruitment process, my lord. We are the candidate.
IA no notice has been issued.
No, it has come up for the first.
So you want to file objection.
Yes, lordship.
So let us issue notice here. Heard Mr. B. Kaushik, learned counsel for the petitioner. In the IA, issue notice. Returnable. How much time do you require?
3 weeks.
3 weeks. Returnable 3 weeks. MSR
Kakoti.
appears for
Respondent number 6 to 23.
appears for respondents 223 who are sought to be impleaded as party respondents in the accompanying writ petition being WPC 1256 of 2024. Learned counsel submits that she has instructions to file her objections, therefore prays for 3 weeks time. Mr. CKS Borwa appears for respondents 1, 2, opposite party 1, 2, 3, 4 and 5. Mission Director, Mission Vatsalaya, Social Welfare, you can appear. 1, 2, 3, 4, 5. Let the matter be listed immediately after the returnable date. Meanwhile, the respondents may exchange their pleadings, and extra copies be furnished within 3 working days to the respondents.
And also, if WPC, there is an interim order, it may be continuous.
Interim orders passed in WPC so and so, if any, will continue. Then we'll fix a date.
Yes,
At least on 1st of September.
Yes, lordship.
1st of September.
Grateful.
I think 27.
IA for impleadment, my lord. During pendency, my lord.
IA for?
Impleadment, my lord.
Oh.
My lord, respondent during pendency of the contempt petition, respondent number 1 and 2, my lord, retired and transferred, my lord. And in place, my lord, respondent number 4 and 5. Charged, my lord.
Any objection by any counsel?
I have no objection, my lord. I am appealing for respondent number 3, my lord.
3.
Please.
Yes.
1, 2. I am for 1 and 2.
1 to 2.
Any objection for impleadment? Heard Mr. K.R. Patkiri, learned counsel for petition. Okay, to IA 2451. This IA has been filed seeking impleadment of opposite parties 4 and 5 in the accompanying contempt case, being contempt case number 431 of 2024. It is submitted that the respondents in contempt case number so and so no longer has demitted their offices, and in their place the opposite parties 4 and 5 are have been appointed. Stop. It is submitted that since the directions contained in the order dated so and so passed in WPC so and so has not yet been complied with, and presently the opposite parties 4 and 5 have been appointed to the post of additional chief secretary to the government of Assam Panchayat and Rural Development and commissioner Panchayat and Rural Development Department. It is necessary that the opposite parties be arrayed as party respondents in the contempt case number so and so. So MS
P. Thapal.
P. Thapa, Learned Counsel, Standing Counsel for the Panchayat and Rural Development Department, submits that she has no objection. Mr. A. Bhattacharya for
Respondent number 3.
appears for respondent number 3. Better. Considering the submissions made by the counsel for the petitioner and also considering the submissions of the respondents, this court is of the view that this hearing can be allowed at this stage without issuing notice. Stop. Opposite parties 4 and 5 are therefore arrayed as party respondents number 4 and 5 in contempt case number so and so. Although the opposite parties will be afforded opportunity to file their affidavits in the contempt case. Stop. The learned counsel for the petitioner will file amended course title before the registry within a period of 1 week from today. I accordingly stands allowed dispose of the contempt case. You write, in view of the order passed today in IA number so and so, Namgeta DDO, opposite party 4 and 5 Namgeta are arrayed as respondents 4 and 5 in contempt case number so and so. The petitioner will file amended course title in before the registry within 1 week from today. Let notice issue returnable 4 weeks since MS Thapa, Standing Counsel for Panchayat and Rural Development Department, is present in court, and she accepts notice on behalf of newly impleaded respondents 4 and 5. Accordingly, let the notice be made returnable after 4 weeks. The respondents, newly impleaded respondents, may file their affidavit if so advised in the meantime. List after the returnable date.
28 also same, my lord. Same, my lord.
Which?
28.
28 to some. Same order in 28. In 28, that IA 2452. Dispose.
Obliged.
29.
Hello. Yes, I has been filed for impleadment on the opposite parties, my lord. My lord, in this case, the petitioner has challenged the provisional gradation list. Earlier, some of the
Then we'll issue notice here because private respondents are there. You have not given the addresses. How will you take steps?
hello, they are working in the office of the director, my lord. All of them.
I heard Mr. Dr. P.K. Goswami, learned counsel for the petitioner, and Mr. M. Via for Department.
Health Department, Lord.
And for 3 to me, private respondents.
And Mr. S. Doctor appears for respondents 3 to 9. Stop. This IA has been filed for impleadment of the opposite parties 1 to 26, who are also employees under the Directorate of Health Services. Stop. This IA, the impleadment has been sought for as the petitioner has challenged the provisional gradation list published on 12/3/2025, 2015, by filing the accompanying writ petition being WPC 4287 of 2017. It is submitted that since in the event the provisional list is interfered with by the court, the opposite parties may be affected and therefore they are necessary parties before this court. Let notice issue on the opposite parties 1 to 26. Steps be effected by the petitioner through the office of the Director Health Services, Hengrabari, Guwahati. The Learned Council will ensure sufficient copies of the writ petition are furnished to the opposite parties 1 to 26, and the steps are undertaken through the office of the respondent number 2, opposite party respondent 2, Director of Health Services. The Director of Health Services will ensure that copies of the writ petition along with a copy of this order be furnished to the opposite parties 1 to 26 in the present IA. The opposite parties are at liberty to file their objections, if any, by the next returnable date. Matter be listed after 4 weeks.
Supplementary list for order section 70.
None appears for the parties on hold. Matter stands passed over to be listed next week.
I think item 68.
Yes.
It's a matter, I'm challenging an order of an attachment, my lord.
Challenging the order
Of an attachment.
Hmm.
This order was passed on 16th of July 2025. And my grievance is twofold, my lord. One is that this order of attachment is without any jurisdiction in terms of an executive order which I'm relying on and is placed on record. And if I'm able to satisfy your jurisdiction level, Your Lordship, then this other part of it is the mala fide part of the order which has been passed. On the last occasion when the matter was listed, it is in terms of an executive order where they said this is only can be done if it is an approval from the competent authority is required. That is why it was posted for an instruction. But before that, my lord, I'll just take your lordship to the impugned order that has been passed. That's on 16/7/2025. This is, my lord, is at page 46, annexure 10. I joined services in 2013, my lord. I was presently working as a superintendent of taxes in Guwahati. It was in this verse that this order has been passed where I've been attached. I just read the relevant part, which is the number 1, which is 109, my lord. There are 2 people orders are passed. I'm concerned with the first part. For the smooth functioning of the official works and in the interest of public service, Mr. Bora, which is my client and petitioner, Superintendent of Taxes Guwahati Unit B, is hereby temporarily attached to the Office of the Superintendent of Taxes, Naharkotia Unit, Naharkotia, with immediate effect and until further orders. Mr. Bora, Guwahati B, Superintendent of Taxes, will continue to draw his pay and allowances from his permanent place of posting. Now, this order, my lord, in terms of an executive order which the government has passed, my lord, is in page 54, is without any jurisdiction. Is at page 54, annexure 14, my lord. I'll just read this. This is dated 26th of January 2025. While reviewing the schemes of Dumduma LSC, it has come to the notice that many staff and officers of various departments have attached in different districts without proper approval of the competent authority. In some cases, director or district level officers have issued attachment orders, which is an illegal and irregular practice. Such practices create administrative inconvenience and defeat the objective of transfer of the policy of the government. Immediate orders may be issued to cancel all such attachment orders given by the authority of the department, and all such officers should be directed to report to their original place of posting within 1 week without fail. Now, the reason I'm saying is, my lord, if your lordships goes back to page 46, why I'm saying this is without jurisdiction and any approval is because this order was passed by the Commissioner of Taxes, Assam, my lord, at page 46, if I can also take back again to the same order. 16th of July.
Yes.
The competent authority, in my opinion, would be the Commissioner and the Secretary Finance Department, my lord. This order has been passed by the Commissioner of Taxes, Assam. And if your lordships will see it copy, it is not even marked to the Commissioner and the Secretary. So this is a decision taken unilaterally by him without any approval of the competent authority. Therefore, this order on the face of it is passed without any jurisdiction. In terms of this, my lord, why the order is posted with mala fide? This order was passed, my lord, in terms of an application that was filed for registration of a GST by respondent number 8. Now, she had applied for the registration, my lord. That registration application was verified by our office, and an order was passed where it was first cancelled because of certain deficiency in documents. The second application came to be filed. There was again a verification report where there was certain deficiency being pointed out, for which I had to cancel it again. Subsequently, my lord, there was a lot of pressures from the higher authorities that this has to be done in whatever manner, and I have relied on certain SMSs which have been also flown to my WhatsApp and which has been annexed. Subsequently, my lord, the third application came to be filed. In that, my lord, there was again a verification done, and once all the verification was done and the due process of law, the approval was granted. The date of the approval is extremely important because, my lord, that's the date is 15th of July. Exactly next day, this order has come into play. In terms of my two other rejections that has happened. Now, why I am saying that there was a pressure, my lord, I have relied on certain WhatsApps, the WhatsApp which has been communicated to me in my mobile, my lord. That is at page 40, Annexure 6. Fourth July is the first, and second is the 9th July, my lord. I hope they are clear. Yes, my lord. On 4th July, this is sent by Manoj Sharma, DT, Lordship has seen it, Deputy Commissioner, Taxes, and it says, do the registration urgently. Message from so and so.
He's the addition.
So he's the additional commissioner.
Sabdullah.
Sabdullah. Then comes on the 9th of July. Please look into, on the next page, my lord, it says, Sardullah sir has sent this at the bottom. So on the last occasion, query was put by the Honorable Court that why haven't you made him a party? So in terms of that, my lord, I have moved an application where he has been now also made a party, saying that this instruction has flown from him. So therefore, my lord, in terms of this instruction, which the government still relies on, I hope there's a competent authority approval, this order is passed completely without any jurisdiction. And in terms of that, my lord, I had filed a representation before the authorities, my lord. That is at page 52.
The impleadment Yes, yes.
Yes, my lord. Page 52, my lord. The second part of the representation. Further, the attachment order, my lords have it on the second paragraph, page 52. The attachment order dated so-and-so has been issued without approval of the competent authority and is in violation of the instruction dated 26/1/2005, which prohibits officer of attachments are illegal and irregular practice. The attachment is in violation of the OM dated so-and-so and OM dated so-and-so.
This is your representation.
My representation. Because after that, my lord, I have been on leave. I have not joined my position.
You have also not marked it to the Commissioner and Secretary.
I have marked it to the Commissioner of Taxes, my lord. That is the authority who has given it to me. The letter.
Not to the Secretary, who you say is the competent authority.
No, my lord. This has been sent to the Commissioner of Taxes.
Yes.
First of all, regarding the authority, my lord, section 3 of the, my lord, GST is very clear, like in the, my lord, VAT Act. It is the commissioner who is the head, my lord, and, my lord, all other employees are under the commissioner are under him, my lord, including, my lord, this superintendent of taxes, my lord. So there is the dispute regarding the authority of the, my lord, Commissioner of Taxes to, my lord, issues are order. So, my lord, my instruction in this regard says that, my lord, for administrative reason, he has been, my lord, put on attachment in that particular post from Guwahati. And, my lord, already a file has been moved for his transfer, which is under consideration at the highest level, in a government level.
But you try to take somebody and then you want him to come back to his original place of posting for his salary. What is this?
No, he won't come back for salary here, my lord. It's online, it is paid, my lord, to the account. It's not that, my lord.
Distance is 458 kilometers, my lord, from Guwahati.
No, he
where
need
I've
not
been
have to
attached.
be, my lord. Otherwise, my lord, lordship will see the last para. It's very, my inspection is very clear, then my lord, already a file has been moved for his transfer. Lordship will see, my lord, para 4, 5 and 6 in this regard. And regarding salary part, he need
What
not
about the
very much.
policy decision that you have already taken not to attach people?
No, yes, my lord, may I point out here, my lord, that part, page 54, lordship will see. The third para. It says, my lord, only when, my lord, beyond authority, somebody is, my lord, transferred. If at all, my lord, this attachment is beyond the authority, of course, the senior officers will, my lord, have a look into it, my lord. It's
No,
not that,
you
my-
read the first paragraph.
While reviewing the schemes under so and so, it has come to notice that many staffs and officers of various departments have been attached in various districts without proper approval of the competent authority. In some cases, director or district level officers have issued attachment orders, which is an illegal and irregular practice. Such practices create administrative inconveniences and defeat the
So
objective.
who is
of
the competent authority?
Commissioner of Taxes, my
No, no,
lord?
are you saying that for transfer only the commission?
No. Transfer, my lord, it will have to be it for
All
the
right, attachment.
attachment, of
only,
course, my lord.
only the commissioner's signature is necessary. Doesn't
Yes, ma'am.
require,
That's
the
what
file
the
doesn't
instruction
move
says.
to other higher officials.
That's what the instruction says, my lord.
No.
Because lordship will see, my lord, the provision, my lord, in section 3 of the, my lord.
And what about transfer?
Transfer, my lord, they will have to move the file, my lord. Yes, of course. That's a separate issue. You will have to be moved from this particular post to a different post.
No, that's all right. But how do you issue transfer orders? By the commissioner? If he is the supreme authority of the department, is the head of the department?
No, it will be by the appointing authority, my lord. That is the government, my lord. So in case of transfer, I suppose. my lord.
Then if you can't transfer him, then how can you attach him? Like that?
Then, my lord, in this regard, my lord, I will have to seek instruction from the
You
government, my
have
lord.
to- you
Yes.
have to get your
Whether, my lord, this
Get your
particular
instruction.
order.
My lord, is lordship's permission, the planning of proceed, page 30, annexure 1.
Page?
That's page 30, annexure 1. That's my transfer order.
Yes.
This is dated 11th of March 2024.
Mm.
In the interest of public service and compliance of the guidelines of so and so issued to the resident, the Superintendent of Taxes is hereby transferred to the post. Your lordship will come to page 31. My serial number is 51. The petitioner, and your lordship will come to page 32. This is a trace. Your lordship will put a question: who's the transfer authority for transfer? If your lordship sees the signature is the Secretary of the Government of Assam Finance Taxation. So the transfer is this authority.
Para 6 of my instruction, lordship will see, my lord. It says that, my lord, the proposal for transfer has already been sent to the government, my lord.
No, correct.
So meaning there, my lord,
There
we'll have
are-
to take the, my lord, consent of the government or approval from the government, my lord.
So there are certain views given by the commissioner,
Lordship.
which may or may not be considered to be
Punitive also. my lord.
punitive
Yes.
against the petitioner. That's on a different issue, but what we want to say is that if for a transfer you require a particular procedure, how on attachment you can suddenly, it's almost as good as a transfer.
No, my lord, but.
Is there a provision
No,
under
lordship
the,
will see, my lord, in the para 6 you have stated
is
that in
there
the
any-
meantime we have
is
moved.
there
my lord.
any provision under the rules, specific provision for transfer, for attachment? No.
In terms of
Otherwise,
the-
it is
on
it is an
administrative side, they
administrative,
can, my lord.
it is an
provided-
administrative
Yes,
existence
yes.
by which you resort to.
Yes, my lord.
So therefore,
In terms of this notification, my lord, 26th of
No,
January.
lordship will see para
2025.
4 again, my lord. It says, my lord, it was observed that so and so, that is the petitioner, was unable to cope up with the
where
pressure
are
of
you
the
now?
board.
I'm on leave.
He has
I
taken
was
leave,
from
my lord.
Guwahati, I was transferred there. I was posted there.
You get your instructions on this. Why he has been,
No, region we have given, my lord.
Huh?
Region, it has been stated in para 4, why he has been, my lord, moved out of, my lord, Guwahati.
that is not a ground to attach somebody like that. You transfer him.
No, that file has been.
What is that urgent reason that he has to be moved out of the office till he's formally transferred? What kind of an administrative exigency is this?
My, he says, my lord, he is unable to, my lord, cope up with the.
All
pressure
right,
of
he's
work.
unable to, you put him on leave, you ask him to go on leave.
No, it's no
You-
point, my lord, keeping him on leave, my lord, by paying him, my lord,
He's
without. work.
already on leave.
No, he's on leave.
He's on leave.
Yes, on leave, he is on earned leave. Yes.
Whatever. Firstly, you say he's unable to cope up with
Yes, my lord.
work.
That's
Then
why, my lord, we have moved the file for, my lord, transfer.
So he will create the same problem there wherever you send it.
No, there, my lord, like, unlike in Guwahati, my lord, their pressure will be, my lord, less, my lord. That's why, my lord, considering everything, this was done, my lord.
All right, we give you some time to complete your instructions as to what has
Then
happened.
Monday, my lord, Friday.
Monday. 11th.
This order still remains this order.
Hmm?
Your lordship
He's on
still then
leave.
at least keep this in abeyance, this order.
Yes, we'll keep it in abeyance, but
Lordship,
let him get
Monday-
his instructions
Yes,
on Monday.
Monday, my lord. No
And
problem.
on Friday, my lord, short instruction, I can play this in the
Monday.
motor stage.
Monday, Friday, I'm not available.
Counsel for the parties.
Then,
Petitioner is aggrieved by the order, impugned order of attachment, whereby the petitioner, although posted in where are you posted?
Guwahati Zone B,
Guwahati Zone B. He has been attached to
Naharkotia
unit.
Yes.
Naharkotia. With immediate effect by the impugned order dated 16th of July 2025. Petitioner submits that this impugned order of attachment is contrary to the rules and procedure, as the same has been issued unilaterally by the Commissioner of Taxes, namely respondent number respondent number 3, who is also being added by name as respondent 4. Stop. Who is respondent 8?
This is a private respondent, madam.
Who complained regarding their registration?
Yes, that registration that was done, she is Deepanjali Doctor, madam. She is the private respondent.
Why you added him? What relief are you
Because-
claiming?
No, because it is her complaint which has ultimately led
What
to that.
relief are you claiming against her?
Nothing, but the complaint has originally come from her that I was not, I have not.
Unless you
given
are
the-
claiming a relief, why is she added as a party? You must claim a relief.
I deleted, my lord.
Learned counsel for the petitioner submits that this impugned order of attachment is also contrary to the policy decision adopted by the State Department at the highest level, where such attachment orders given by authority without proper approval are required to be cancelled, and explanations are to be called from all such officers who had issued attachment orders beyond their authority, mandate, and power. Stop. He therefore submits that this attachment order is totally unwarranted. The entire process leading to his attachment is at the behest of the private respondent number 8. And one, who is he? Who is the other person? WhatsApp.
Yes.
He has to be implemented.
He's
my lord.
yet-
There is a-
this app- He's
And
official.
another
capacity,
senior
my lord,
officer
is the
of the department who is not included in the.
5 and 6, my lord.
Hmm?
5 and 6
What 5 and 6?
respondents. Additional Commissioner Taxes and Deputy Commissioner Taxes.
But they are not added by name.
For that, we've moved the side, that I which we moved, it was not.
You have filed an IA.
Yes, my lord.
It's there today, it is listed.
It is listed tonight.
Oh.
That's in terms of the last
Take
order.
one, Diana, you can-
In terms of the last order.
The standing counsel, finance, Mr. B. Gogoi. Additionally, B. Gogoi, standing counsel, submits that he will obtain instructions in the matter. He submits that the attachment orders are issued for exigencies of, for administrative exigencies. And there is already a proposal initiated by the department for transfer of the petition. And until such proposal is approved and transfer orders are issued, the petitioner has been attached at the present place of posting, as is unable to cope up with the work pressure in his current place of posting. So let these instructions be placed by the learned additional lady on Monday, 11th.
I will file one short affidavit.
We'll take up your IA on Monday only.
Monday.
Depending on what orders we pass.
Yes. Great.
This writ petition along with the IA on Monday.
Great.
Maybe for admission, item 30.
Met privilege. Petitioner superannuated on 15/2/2018. Provisional pension was given to him. Thereafter, he died, my lord. And at present, my lord, his widow is before your lordship. And she is not getting pension for 7 years, my lord. Notice served,
Yes.
they have to file response. my lord.
Who against which department?
My lord, it is Gram Shabok, my lord, Panchayat and Rural Development.
Panchayat and rural. Huh? Instructions. 22 matter, you're still awaiting instructions? Then who's you're appearing for?
I'm for respondent number 12, your lordship.
Respondent 12.
12. We have entered. My lord, 2 weeks time may be given for filing our affidavit. ma'am.
It's respondent 12.
My lord, the headmaster of Krishnai, Habragat Gop High School.
Your amended post title does not contain that page.
My lord. Yes, respondent number 12, my lord.
Respondent 12 is arrayed subsequently.
Yes, my lord. Subsequently, my lord. By IA.
After that, you filed amended post title.
Yes, ma'am.
It is not here. Respondent number 12.
11, my lord.
Huh?
I'm sorry, my lord. 11 is replaced by 11. Because, my lord, school was merged with another school. 11 was replaced by another new school, my lord. That is 11. 11 is replaced by 11.
11 is replaced by 11.
Yes.
What is the meaning of that?
My lord, he may be struck down, my lord, that respondent number 11.
But then, my lord, here this notice I have received. Wherein, my
Your
lord,
lordship
the
would be
first
pleased to
title,
see
front
this
number 12
petition, my
appeared.
lord.
Your pro forma
IL
respondent.
1347.
No, my lord. The newly impleaded respondent.
No, pro forma respondent.
Oh, yes,
Pro forma.
performer, so newly impleaded, but earlier he was not there.
Because my lord, school was masking.
Respondents will file their affidavits within 4 weeks. List accordingly.
Much of.
Title 31.
Yeah, please, lordship. Lordship, affidavit has not been filed.
Lordship, we need 4 weeks time to file our affidavit.
Hmm?
4 weeks time to file our affidavit for
Yes.
respondent number 2.
Any objections?
No, lordship.
Counsel for respondents pray for 4 weeks' time to file affidavit. Prayer made is not objected to by the counsel for the petitioner. List accordingly after 4 weeks.
Right.
32.
Same, lordship.
Same lordship.
Same.
Same.
All right. 31, 32, same orders.
Right.
Oh, thanks.
34.
May I please, Lordship? The petitioner has already retired on 30th June, my lord, waiting the order, my lord. But
You are praying for promotion.
yes, my lord.
But you
Promoted
have
people,
superannuated.
my lord.
You have superannuated in the meantime.
Yes, my lord. But promoted, but in the same rank, my lord, not the higher post.
How can you be promoted to the same rank?
It has done, my lord. But I was appointed as model supervisor, and now the promotion is given to me, laboratory technician, which is equivalent, my lord, as per the office note, my lord.
All right, you file your affidavits.
Yes, lordship.
How much time?
Lordship, 2 weeks time, lordship.
My lord, so already so many time they have taken, my lord.
Lordship,
But you have retired.
Yes, my lord.
The only benefit we can give you, if we find justifiable, is notional benefits.
Yes, my lord.
Heard counsel for parties, Mr. C. Sharma. Learned counsel appearing for
Water Resource Department. lordship.
the Water Resources Department. Is permitted 2 weeks further time. Complete his instructions and file affidavit. List accordingly.
Obliged.
35.
Happy, sir. Okay. This case, lordship, on 25/10/2024, lordship notice was issued, and thereafter also they have paid and signed, lordship. Our once is that similar benefits was given to the other employees, lordship, and we are relying to judgment, lordship.
Lordship, we
We
have
have annexed
received
in-
some instructions, but it is not complete, so I'll pray for some more time, lordship.
You tell us whether the judgment is applicable here. Which judgment is it?
Lordship, initial judgment, lordship, page 43 to 50, lordship, whereby the similar situated in a petitioner, one of the petitioner also directed to regularize, lordship.
Why is he come back again?
And thereafter, they have not taken step, lordship, now by judgment dated, lordship, 14/8/2024, lordship, similar situated page 85. This honorable court has directed to for regulation, lordship. If lordship, use the page number 44, lordship. Start from page 43. Page 44. Gunoram Bora, he is the petition number 6, lordship. In civil rule number 554/94.
Gunoram Bora, and offered it past page 49. Last page.
Like, third counsel for parties. How much time do you require?
Another 2 weeks or so.
2 weeks?
Fix it.
The Mr. Sharma will appear, will obtain instructions and complete. And as to whether the judgments referred to by the counsel for the petitioner will cover the cases of the petitioners as well. This matter again on 27th August.
Hello, please.
August.
27.
Please, Your Lordship. I need 3 weeks time to file my response to their affidavit. They have.
Mr. E. Biswas, one of Biswas, learned counsel for the petitioner, submits that he would like to file
My
a
affidavit.
response to the objections filed, affidavit in opposition filed by the respondents. Prayer made is allowed, list after 3 weeks.
Well, can it be on 3rd of September? Your Lordship?
3rd September. This
Obliged.
one, 3rd September.
Matter pertains to non-revision and non-updation of the pensionary benefit of the petitioner who was separated in the year 2016. He got retired, Lordship. And thereafter, he has been getting a fixed pension, Lordship, of 10,300 for this last 8 years. Lordship.
We are yet to receive the copies, Lordship. We
Copies
have
of
not
this,
received
Lordship.
yet. Copies of the AG.
PhD.
9 years. 1 year.
Mr. Dhor,
My lord,
any instructions?
no, my lord, the thing is that it is the accountant general, my lord, they have to take action, my lord.
We didn't receive any copy from.
Allegation, whatever the grievance is on.
You serve
AG,
copies, Mr. Hussain,
Two
the
copies,
accountant
Lordship.
general.
2 copies need to be.
Hmm?
Two
Lordship.
copies, Lordship.
2 copies you want?
Yes, yes, I'll
Lordship,
Give
1
him,
photo.
give him 2 copies.
And Lordship, the
This-
fact is that there is nothing with the AG office because the
It is the administrative
book has been
department
lost.
who has
My lord,
supplied.
the thing is that AG did not return his service book, my lord.
Oh.
but the last
That is the thing, my lord.
but the last page of the petition will clarify that the AG has returned, Lordship. Page 46 will be there, Lordship. Herein is at column 10, Lordship. The service book, IP statement, etc., leave account are returned herewith for record of your office. This is the letter of the AG office.
Yes, Mr. Dhor. This
Lord,
sent to Under Secretary PWD building.
My lord, I will take the instruction, my lord.
So there is lack of communication on part of the department for which I am suffering now. Others are getting this.
Mr. Dhor, please get your instructions
My-
2
my-
weeks.
my-
Since this matter pertains to the non-revision of the pension of the petitioner. Further 2 weeks' time is granted to the counsel appearing for the Mr. Ardhor representing the PWD department. As well as Mr.
Need also on behalf of B. Sharma.
The so-and-so appears on behalf of Mr. So-and-so for Accountant General. Let the standing counsels complete their instructions and apprise the court positively by the next date fixed, list on 29th August,
Well,
29th August.
problem.
Item 49 to 41.
Lordship, regarding my lord, it's a promotional my lord examination. The petitioner's grievance is that my lord, the rule says my lord, they will have to be graduates. But this time, my lord, we have given my lord both graduates and undergraduates, so that my lord, the undergraduates, they get a chance, my lord, one last chance to participate in the selection. Because suddenly the amendment was brought in from my lord, matriculation to my lord, it has been made my lord, graduation. So now, my lord, we allowed them to participate, but the result is this, my lord, that for out of 240 candidates who were called for, only 84 appeared. And 10 has been, my lord, otherwise selected. It's now lying with the government for approval. And all these 10 candidates are graduates. So 50 out of 60 posts, we, if at all, my lord, this writ petition, my lord, writ petition is dismissed for not allowed. In that case, my lord, we can fill up only 10 posts now. And all are graduates.
And how many posts are vacant?
Vacant total was 60. So they were against the my lord undergraduates. They wanted that my lord, they should not be given the chance. But even though we gave a one-time measure, we gave a chance, my lord, or opportunity. It is only the graduate, my lord, 10 candidates, they were selected. 50 is left out. So they can again participate when the my lord, selection is made. This
No, my
is the
lord,
figure.
these
Otherwise,
10,
my lord.
these 10 who have come out successful, if they are graduate, number one, and number two, if they are senior to me, I have no objection. But if they are junior to me, my lord, then my writ petition will become infructuous. My lord, matter is very simple. Earlier, as long as Rangaya's law was holding the field, my lord, the law which was prevailing on the date of accrual of vacancy, that would be the law. Then subsequently, my lord, Supreme Court says that no, law prevailing on the date of selection should be made applicable. Now, my lord, normally state government speaks of law, they often speak of, my lord, Uma Devi, these, that. How come they are promoting, my lord, persons who are not even a graduates? The rule prescribes graduate. Lordship knows earlier, my lord.
You are graduates.
I'm graduate. Well, our case have not even been considered. People who are
Because
not.
of the undergraduates being within the zone of consideration.
Yes. Now government will go for my lord that 50 posts. Additionally, my lord, whatever is in between as my lord fallen vacant.
Now,
They can
whether
definitely
these 10 persons are senior to them.
that I can place, my lord, because results have not been declared.
Must
I
be
can
senior.
place it in a seal cover.
May not
based
be,
on a
my lord.
report.
Maybe, may not be. We never know, my lord.
No, if they are juniors, then how come they are included in the zone of
That's
consideration?
people who are not even graduates, I can follow. Even non-graduates, according to us, my lord, in that list of 242, yes, out of 240, my lord, 198 are overaged out of 240. 42, only 42 are eligible. Well, our case is very simple. We are graduate. We are in the zone of consideration. Our case should be considered. Right to be considered for promotion is a right that has been denied to us, my lord. You have undertaken an promotion exercise by including people in the zone of consideration, number one, who are overaged, number two, who are not graduates, and some retired person are also there, my lord. So how can this be permitted, my lord?
So that's why I'm placing in, let them have the instruction from the client, my lord. This is the present position. And my lord, that 10
the instructions whether these.
I will place it in a seal cover because it has not been published. Lordship may have the instruction then. Because my lord, that we can verify. Those 10 persons, whether they are my lord, junior
Now,
or
what
senior.
is your grievance?
Our grievance is, my lord, which our case should be considered in the same exercise.
No,
If the ones they consider will be promoted.
Now there are 50 vacancies.
Yes.
In this 50,
Let our case be considered.
if the undergraduates are not there, you will be included
Yes,
in the
yes.
zone of consideration.
Yes, yes.
They, now, my lord, so far as the my lord, if subsequently if we hold my lord any such examination, say for the 50 posts or my lord, additionally whatever comes in, then my lord, all the graduates will be called for, including the petitioners. There is no dispute regarding that. As a one-time measure, a policy was taken.
So that policy, you don't want to extend it to the 50 posts for undergraduates?
No, already one time it is over. If this particular selection is not interfered with, my lord, that policy is over. We have given them opportunity. Some of them participated. And despite that, my lord, they could not succeed. All
My lord,
that's why I am
My lord
placing-
can
otherwise-
record this submission.
Yes.
Only two rider, my lord. Out of these 10, if somebody is junior, that should not be promoted, number one.
No.
And number two,
No. If somebody is junior,
Huh.
then you are entitled to challenge the selection, or maybe after you are promoted.
Let it be on Wednesday, I will place the instruction, my lord,
Then the
about this.
seniority. But to say that if somebody is junior, they should not be promoted will require.
possible make that observation. And secondly, that 50 posts should be according to the amended rules. Then it's okay.
Yes, and that is a.
Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. B. Purukashta, Learned Counsel for the petitioner, Mr. B. Gugoi, Learned Additional AG, appearing for the state. The petitioners are employees of the State Taxation Department.
Yes, my lord, we are working as my lord.
Senior assistant.
Yes, senior assistant,
Nazir.
Nazir, etc.
The petitioners are presently serving as senior assistant / Nazir in the State Taxation Department and posted in various stations. So it is the case projected on behalf of the petitioner that pursuant to the amendment made to the service rules. What are your rules called?
1 second, my lord. The rule is at page number 31.
Assam Taxation Service Rules 1995.
Assam Taxation Service Rules
1995,
1995, which came to be amended in December 18th, 2020, whereby the qualification for promotion to the next higher post of
Inspector of Taxes. Inspector of Taxes.
Inspector of Taxes has been amended, and the requirement is graduate
Yes.
or possessing equivalent degree from government recognized university. Stop. It is the submission on behalf of the petitioner that all the petitioners are graduates and are eligible to be considered for filling up of the vacant posts of inspectors by way of promotion as per the rules. However, the government
2020.
proceeded to include certain persons who were undergraduates.
Number one, who are undergraduates, and number two, overaged, and number three, 5 retired persons are also there.
Who were also overaged, and further some retired persons were also permitted to apply for being considered for promotion to the post of inspector. Stop. This prevented the writ petitioners from being included in the zone of consideration in respect of the vacancies which were notified. So consequently, the petitioners are before this court putting a challenge to the said process initiated by the department for promotion of those persons who do not satisfy the requirements under the amended rules, namely those who are not graduates or overaged or even retired. Stop. Notice in the matter was issued, and
Affidavit
some interim order was passed earlier.
Yes, ma'am.
Not to declare the.
Not to declare the result.
An interim order was passed, directing the respondents not to declare the results. So, but today when the matter is called up, Mr. B. Gugoi, an additional AG appearing for the state, submits that this exercise undertaken by the government was a one-time exercise permitting both the graduates as well as the undergraduates who were otherwise qualified under the pre-amended rules to appear for selection for promotion to the higher post of inspector of schools. Stop. Inspector of taxes. Stop. It is submitted by Mr. Gugoi that in respect of total vacancies available to total vacancies of 60 posts in the cadre of Inspector of Taxes, pursuant to the selection process, only 10 candidates have been considered to have cleared the examination. Stop. The results have not been declared in view of the interim order and are placed in seal cover. Stop. He further submits on instructions that the balance 50 vacancies which are available, for which the government will shortly make arrangements for selection and promotion, will only be available for candidates who satisfy the requirements under the amended rules, namely those who are graduates. Stop. Having heard counsel for the parties, this court is of the view that if as submitted by the learned additional AG appearing for the state, that out of 60 vacancies, only 10 vacancies have been filled up and 50 vacancies are yet to be filled up, and the government is undertaking the necessary process for filling up of these posts by adhering to the amended rules and by permitting only graduates to be considered for promotion, this court is of the view that the matter can be closed, recording the submission of the learned additional advocate general, that the government will only permit graduates and others who satisfy the amended rules, the eligibility criteria permitted under the amended rules, amended by so-and-so amended act. And while undertaking the process for filling up of 50 vacancies in the cadre of Inspector of Taxes. Stop. Once the process starts, if the petitioners are found to be eligible to be included in the zone of consideration, their cases will also be considered, and they will be permitted to participate in the process which is undertaken. Stop. The other apprehension expressed by the learned senior counsel that the 10 selected persons, if are found to be graduates and junior to the present writ petitioners, their appointment, their appointments, they should not be permitted to join in their posts until and unless the petitioners' cases are considered subsequently, can be taken care of by directing the respondents, by permitting the petitioners by giving liberty to the petitioners to approach this court, challenging such issues relating to seniority if such an occasion arises at any given point in time. Petition.
Our Lordship has recorded that amendment is of 2020.
18-12-2020.
Page 35.
18-12-2020.
One more minor slight correction, my lord. The government is not initiating the process. Government will initiate the process for filling out the 50.
Proposing to.
Yes, Lordship has said it is, my lord.
Proposing to initiate.
And my lord, I made the submission that my lord, all 10 are graduate. It's there, my lord, in the note also. It's all are graduate. 10 who have been selected are graduates. My Lordship will.
And seniors,
Writ petition disposed of. The interim order stands vacated.
Yes.
The respondents will be permitted to publish the results accordingly and proceed.
That is 42 to 53 minutes.
Lordship, in this case, petitioners have advanced their argument. On last occasion, Lordship directed me to submit a list. Lordship have prepared a list and submitted to all the petitioners also.
Today?
No, earlier.
Okay.
Lordship, item 43 is relating to issue of, so they have challenged the so-called notice.
List doesn't exist.
My lord, that should be de-linked separately should be had. This is not related to the series matter. 43 BSNL matter, that is not the same matter as the linked matter.
No, Lordship, here difference is that, Lordship, 12 writ petition has been filed. Out of that, item 43 relating to, they have challenged the so cause notice.
Give us the list
I have given already list.
or send us a soft copy.
What's for the- Lordship, item 43 and 52 are different. 42, 52, the order in appeal has been challenged.
Where are the councils? 42 and 52.
43 is Mr. Sau is there.
You want it segregated?
Yes.
Item 42 and
No, 43 and 43.
43 and
52.
52. In view of the submissions made by Mr. SCKL and not disputed by the council, who's for 52?
He's showing Mr. Goyal.
Amit Goyal.
It is submitted that these
This one.
matters challenge the orders of
Lordship, here they have challenged in 43, they have challenged the so cause notice also.
show cause notice.
Lordship.
That has also been challenged in the other matters.
In other matters, Lordship, order in original has been challenged along with an.
Okay. Then why is segregated?
I think Lordship, point is same, Lordship, we are
Mhm.
taking the plea of maintainability and alternative remedy in all the cases.
No, then let it remain.
I think
Mr.
Lord-
Chaudhary, you have completed your
Yes.
argument.
Our case is very simple, my lord. We say the activity is exempted.
That's right.
And secondly, my lord, there is barred by time. These are the 2 points. And we have given our written argument also, my lord. There are 2 notifications.
We have not reserved it for the simple reason that matters get delayed. So therefore, we are trying to deliver an order on the bench if possible.
Yes, yes.
But somehow or the other, it is not happening. So therefore, if you all agree, then we'll fix a date in
Yes,
September.
yes.
Lordship.
And we'll deliver the orders on, let us say, on 11th of September.
Yes, yes.
No, sorry, not 11. It has to be 16th or 18th,
Anyway, my lord.
16 Lordship.
16th September. So we'll try to complete all these matters on
Lordship.
16th. And arguments have been advanced in almost all the matters. List these matters again on 16th. For orders. Councils may submit their written arguments in the meantime wherever necessary.
There are interim orders, Lordship. There are interim orders, Lordship.
Interim orders wherever passed will continue
Lordship.
until further orders.
Item 54.
May it please your lordship. Lordship, on the last occasion, lordship, I have mentioned a letter from Director of Health Services, lordship, to the Standing Council of Health and Family Welfare Department, lordship, where lordship, the Director of Health Services has admitted that our petitioner is eligible for pensionary benefit, lordship. Lordship, this is the letter, lordship.
Hmm.
This is the fresh instructions, Lordship. Instructions I have placed.
Have you given her a copy? You show her one copy of instruction.
Lordship, we are not aware about this, lordship.
They have written to the department.
No, lordship.
Your petitioner has written to the department.
Yes, lordship, but we are not aware about that, lordship.
So what is
It's
to be,
not connected with us.
what is to be done?
Lordship, if she is withdrawing the pensionary benefit, then lordship, we will withdraw the WPC.
She has requested the department to withdraw
Yes, lordship.
as she is drawing the pension.
Yes, lordship.
She does not want to press the writ petition further.
Yes, Lordship. That's why I'm saying Lordship. If she is withdrawing the pensionary benefit, then Lordship we will withdraw the matter. Lordship, WPC.
So we'll close it.
Yes, Lordship.
All right, heard counsel for parties. MSD Bora for the Health Department has placed before the court copy of the instructions, which shows that the writ petitioner has communicated with the Director of Health Service, informing that she is drawing the compassionate family pension with effect from 5/1/2018 regularly. And there are no more liabilities to be attained from the department, and therefore she has requested the department to take necessary action for closing the present writ petition. Stop. The instructions also enclose a copy of the order according payment of a sum of rupees 1,90,216. For cash payment in lieu of unutilized R&D. Stop. A further order is also enclosed showing sanction for payment of rupees 3,19,220 for provisional death, for provisional death retirement gratuity after deducting rupees 10,000. The order for sanction of grant of compassionate family pension on provisional basis is also enclosed to these set of instructions. So, considering the instructions placed before the court, the writ petition stands closed as the petitioner has received her dues from the department disposed.
Obliged.
My lord, this is a covered case.
My lord, this is, my lord, Lordship, may kindly see this order passed by your Lordship, my lord, in view of the order passed by the Honorable Supreme Court, my lord. My lord, I am praying, my lord, to list this matter along with this matter, my lord. I have taken the plea, my lord. If the arbitration agreement goes, my lord,
What is there to argue? This is already a settled law.
my lord, so my lord, I'm praying, my lord, to list this matter along to this, my lord. My friend B. Sharma is also here, my lord. We are, my lord, similarly situated, my lord. My lord, the counsel for the petitioner is also same, my lord.
11th?
My lord.
My lord, this is a covered case. This is on the default ground. And it is covered by your lordship.
Correct. He
Yeah.
wants to have it on some other day, 11th,
11th,
next
my lord.
Monday.
11th, my lord.
11, 12, my lord.
When is it convenient for you?
13th, my
My
lord.
lord.
But what is the ground for adjourning it? This is a covered matter.
Yes, covered matter.
How does it matter whether this, whatever grounds you
My
want
lord,
to take?
actually, we want to, my lord.
You want to jointly argue?
My lord, together, my lord, we want to, my lord, raise, my lord, this, the ground, my lord. My lord, I'm praying, my lord, humbly, my lord, one adjournment, my lord.
Don't make unnecessary requests because this is all settled by the apex court now. What is there to be argued? It's a binding precedent. When are you available?
My lord, in the first week of September, maybe.
So it unnecessarily gets deferred.
The entire arbitration clause will not go, my lord. The
That's
procedure is
settled
there.
law.
Yes.
My lord, My lord, that
Arbitration
is
clause is
specifically
there.
mentioned in my lord, this order, my lord.
Huh?
Yeah, that is my lord, what's the.
That is the submission we have recorded, that's all.
My lord, the judgment also, my lord, says that, my lord.
Which judgment?
My lord, the honorable apex court judgment, my lord.
Huh? Saying?
Saying, my lord, the last para, my lord.
Which judgment?
My lord. My lord, the moment the moment parties choose arbitration over ordinary civil proceeding for dispute resolution, their duty is to establish an independent and impartial tribunal arises. The substitution of arbitration in place of civil court as an exception under section 28 of Contract Act is only for a forum and not for contracting out of most essential feature of dispute resolution, that is independence and impartiality must exist in every forum. The essential feature is inviolable public policy considering under section 23 of the Contract Act, and from which the parties cannot opt out. Arbitration agreements which are not compliant of the public policy considered are void. So, my lord, it is void, my lord. My lord, it is held that, my lord, the arbitration agreement is void, my lord. That is why, my lord, we made such submission, my lord. My lord, I am seeing only
What
one, my lord.
arbitration agreement is void? Which judgment are you referring?
My lord, please, my lord.
What
This
is
is
the,
my lord, this is a 148 page judgment, my lord. I have only.
no, what is the name of the parties that
My lord,
you can say that?
Yes, my lord, the Central Organization for Railway Electrification.
Then you read the subsequent judgments.
My lord,
The earlier one he is.
my lord, I am
referring,
praying,
my
my
lord,
lord, humbly praying, my lord. One accommodation.
which
my
is
lord.
We'll
overruled.
give you accommodation, but if you are unable to satisfy, we'll impose heavy cost on the railways.
Yes.
We are making it very clear. You're wasting judicial time.
My lord, I apologize, my lord.
On the request made by the Standing Council for the Railways, the matter stands deferred to be listed on 3rd of September.
Yes,
My lord, along with arbitration 4 of 2020, my lord.
It is submitted that a similar petition is also pending, and this matter be listed together along with arbitration petition number
4, my lord.
4 of 2020.
2020, my lord. My lord.
2020.
Yes, my lord. I'll give the number, my lord.
Mr. R. Hussain appears for the writ petition. You remind me to impose cost.
Yes,
We'll
yes,
impose.
yes.
If you cannot satisfy us,
My lord,
we are making it very clear.
My lord, 4 of 2020, my lord. 4 of
4 of 2020,
Yes,
we have said that. List accordingly.
My lord, 1 more 57 is also similar, my lord. 57.
Is it, Mr.? Are you appearing in 57 also?
Yes, my lord.
Is it similar?
Similar, he is saying similar.
All right, 57 also. Same order.
Same.
3rd of August, 3rd of September. Yes. Yes, madam. Any objections?
Objection is there, already I filed the additional affidavit in opposition, lordship.
What is your objection?
Because objection is the limitation period is over, lordship, to approach this authority. Section 11 notice, the Arbitration and Conciliation Act. And annexure 1, page number 6, additional affidavit in opposition.
Section 11.
Yes, lordship.
Where is it? 11(6).
11(6), but here is the section 11.
Where is the limitation?
Limitation is as per CA concern, lordship. So CA is the concern, lordship. Clause 64(1) mentioned as under demand for arbitration. The petitioner, after arising this dispute, after 120 days and within 180 days, have to approach the authority by this notice.
Where is it provided?
So it is the affidavit in opposition. I have
Oh, is it a part of your
kindly
agreement?
see annex page number 44.
Is it a part of your agreement?
Yes, this is this is CA, contract agreement. And
Clause number?
clause number, say 6411, page number 44. Affidavit in opposition. Here it is clearly mentioned, Shiva, I'm reading, sir. In the event of any dispute or differences between the parties hereto as to the construction or operations of this contract or the respective rights and liabilities of these parties on any matters in question, dispute or differences on any account or as to the withholding by the railway of any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision within 120 days, and then in any such case but exception, any of the accepted matter referred to in the clause 63 of this condition, the contractor after 120 days but within 180 days of this presenting this final claim on disputed matters shall demand in writings and the dispute and difference. But the petitioner lordship, as per this clause, the petitioner notice served this to approach this authority after 2 years, lordship.
Where is the notice?
Was the additional and affidavit, affidavit in opposition, additional affidavit in opposition, annexure 1, page number 6. This is the final claim and notice is annexure 2.
It must be in the in the petition.
Yes, my
Where
lord.
is your notice?
Notice is there, my lord. At page 76, my lord. Final claim is there and notice is at page 78, my lord.
It is on 5/2/2018.
Yes.
So why did you approach after 2 years?
My lord, limitation is 3 years. And this restriction is there 120 days. After 90 days, before 120 days. This condition is violated in view of the section 28 of the Indian Contract Act, and there is a judgment also. Because limitation
Contract
cannot be shortened by agreement by the parties.
But this.
There are 2 judgments. It is only their contention that after 120 days, it is barred. Although the Limitation Act provide 3 years for making claim, and thereafter 3 years for appointment of arbitrator.
But lordship, this is as per CA concern. On the basis of CA, the authority allotted to the work to the contractor and petitioner. Then after completion of this work and final calendar, but CA is, in this CA, there is no any mention is this contract act. Is this arbitration and consultation? If this dispute arises, so it's come go to this arbitrator. So arbitration is the Arbitration and Conciliation Act. So there is in this case, contract is not applicable.
No, this is your money claim.
Yes,
Yes.
money claim.
So 3 years.
3 years.
When has your claim arisen?
Here, my lord, from the because final bill was not
prepared in this case. So limitation will start from the date of final bill. But in this case, no final bill was prepared.
But Lordship, final bill.
Final claim you have raised.
Yes, I raised final claim 1/6/2016
Ah,
at page 76, my lord.
ah.
So thereafter, I invoked the arbitration clause on 5/2/2018 within 3 years.
Yes.
But on the basis of the CA and both parties
On
support
the
the
basis of what?
on this seems contact agreement. Yes, this is the contact agreement, but this is the terms and condition. Is this all is there is the contact agreement? Both parties put this.
You
signature.
examine, have you gone through the judgments? The
Not,
judgment which he has placed?
But time may be given to provide this.
You note down the judgments, you share
Yes,
the
I
citations.
will share my.
You address the court on this, whether the limitation provided by a statute, can you exclude it by way of an agreement? Can you shorten it by an agreement?
My lord, every agreement is subject to law of the land.
Yes, Lordship, but this is the contract agreement. The contract agreement is the,
Contract agreement, all right, but
is the allotted
your
period of work.
limitation for money claim is 3 years.
It is the general. It is the general contract.
Then
But
can you
this.
shorten it?
But it is this is the arbitrator appointment is the on the basis of this contract. This contract is this clause is there, and term and conditions is there, and both parties put the signatures. Yes, and that contract should be the followed
If
the
this
terms
is
and
opposed-
conditions.
If this is contrary to the statute law, then your contract is opposed to public policy, not binding, voidable. You have to show that notwithstanding the provisions of section 28,
Yes,
your contract
time may be given, sir. Just
condition
1
is
week. 1 week time may be
permissible.
given to provide these provisions.
On the request made by the counsel for the respondents, matter stands deferred list after 2 weeks.
Okay.
Mr. R. Hussain for the petition.
Patent 58.
Lordship, kindly pass over the matter for today election.
Passed over on the request made by the counsel on behalf of the petitioner. Mr. C.K.S. Borua and Mr.
RB Goswami.
R.B. Goswami appears for respondents.
3, my lord.
3.
So for respondent, basically we have filed a respondent number 1, 2, 6 and 7.
1, 2, 6 and 7 and 3 respectively. Yes.
59.
May I please, your lordship? Lordship, we are submitting the list of judgments as directed by your lordship.
Hmm.
The list of judgments that we are referring to, my lord, is being submitted today.
Judgments for what?
With reference to the last arguments that we have made, my lord, certain judgments that we have relied upon, my lord, has been compiled with and has been filed. A copy of the same has also been served upon the respondent.
But for what proposition?
My lord, I'll come to that, my lord. My lord, first judgment that we are referring is reference to 2025 SEC online 806. My lord, may we please to see paragraph 17, my lord.
What is the name of the party?
Name of the party is, my lord, Advya Projects Private Limited versus Vishal Structural Private Limited, my lord.
Paragraph?
Paragraph 17, my lord.
70.
No, 17, my lord. 17. At page 17, my lord. May I read, my lord? It is also relevant to note that while deciding such an application under section 11(6), the High Court or this court, as the case may be, undertakes a limited examination of As per section 11(6)(a), the court's jurisdiction is confined to a prima facie examination without conducting a mini trial or a laborious or contested inquiry into the existence of the arbitration agreement. Whether there exists a contract to refer disputes that have arisen between the parties to the arbitration. Further, an examination into the validity of the arbitration agreement must be restricted to the requirement of formal validity, my lord. My lord, most of the judgments are being relied upon by us on the point that, my lord, a existence of an arbitration agreement or the clause is sufficient as far as constitution of the arbitration tribunal is concerned, my lord.
What
My
is
lord,
their objection? What is the state's objection?
State's objection, my lord, they have filed an affidavit,
Hmm.
and to that effect, prima facie, they were saying, my lord, that we were not the actual authority who had been made a party to this case, my lord. Though we have,
Where is your contract agreement?
my lord, at page, my lord. At, at page 118, my lord, arbitration clause.
State nodal officer
Yes, my lord.
and ECTA Foundation.
Yes, my lord.
Now,
And the relevant clause is 56, my lord, at page 118.
where is your notice?
My lord, my notice is, my lord, at page 171, my lord, annexure 22, my lord. Since, my lord, the unilateral appointment of sole arbitrator from the state side is subject to the judgment which has been passed by the Honorable Supreme Court, my lord. Parkinson judgment, my lord. That's why the appointment of unilateral appointment by the state for the arbitrator has been barred.
No. First, this is relating to some termination.
My lord, that is to
Now,
termination.
after termination, what happened?
My lord, we have filed one writ petition, my lord, and
Ah.
that was rejected.
Giving you liberty to follow
vote
the arbitration
Yes, ma'am.
clause. Then,
Yes, ma'am. Thereafter, we have evoked the arbitration clause, my lord.
by which communication?
My lord, first we have invoked by a notice, my lord.
Which notice, page
Yes, ma'am.
number?
At page number. At 165, my lord. First, my lord, we have invoked the notice, and thereafter we have filed one arbitration petition, my lord. Thereafter, that arbitration petition was withdrawn by us with a liberty to file again. That was granted to us, my lord, by this Honorable High Court, my lord. And thereafter, again, we have issued the notice at page 171, my lord.
No, we are asking you one thing.
The current notice pertaining to the invocation of arbitration is at 171, my lord.
No, that's all right, but page 165
Yes, my lord.
is a notice you have issued for appointing arbitrators.
Yes.
But there you say that unilateral appointment of sole arbitrator. Who appointed unilateral arbitrator?
No, my lord. Actually, the clause says that, it's clause 56 says that, my lord, that the arbitrator shall be appointed by the state, my lord. The clause itself says that relevant part, my lord. May I read, my lord, that part?
All right. Now, after this 165 notice, why did you issue another notice?
My lord, we have filed in one arbitration petition. My lord, there was some defect to that effect. And we have withdrawn with a liberty to file again, my lord. That was granted to us. That is at page, my lord, 170, my lord.
Yeah, Mr. Nayak, what is the objection here?
Lordship, after the termination, they first approached this honorable court by filing the repetition number 1620/2022.
Yes.
That is at page 161. Lordship, direction was passed, wherein in paragraph 6, Lordship, court clearly said what they are entitled to and what they are not entitled to. If Lordship may allow me to.
Page number?
Page number 164. Paragraph 6. Paragraph 6. It is seen that by memorandum of understanding dated 26/10/2018, the period of engagement of the petitioner was for an initial period of 3 years with effect from 1/1/2019. Therefore, the normal 3-year tenure of the MOU is found to have already expired on 31/12/2021. Therefore, as the contract is found to be determinable in nature, the petitioner is found to be entitled to any further specific performance of contract after lapse of and or expiry of the contract period covered by the said MOU. At base, the petitioner would perhaps be entitled to approach the civil court for seeking damages and compensation if so advised. So what they are entitled to? They are not entitled to any specific performance. That is, against the termination, they have no they cannot have any grievance. And second, for damages and compensation, they were asked to go to the civil court, not arbitration. Last paragraph, Lordship, however, in paragraph 9, page 165. 160? 63. Next paragraph 9. However, before parting with the records, as the learned senior counsel for the petitioner had referred to clause 56 of the MOU, what contains arbitration clause, the court is inclined to provide that the dismissal of this writ petition shall not be a bar for the petitioner to invoke arbitration clause in the said regard. As the present writ petition was filed on 25, this is regarding limitation period, Lordship. So, conjoint reading of paragraph 6 and paragraph 9, they are not entitled to challenge the termination. For damages and compensation, they have to go to the civil court. They were given the liberty to approach the arbitrator, but not for those disputes.
What dispute?
Compensation and damages. Now, if Lordship comes to the notice, Lordship, last notice, Lordship, that is.
Oh, these are issues to be decided. You raise these objections before the arbitrator.
For that, arbitrator has to be appointed.
Correct.
But for if Lordship comes to the notice, Lordship, notice 171, that is 21/2/2024.
Right.
If Lordship comes to paragraph 8, paragraph 8, that it is pertinent to mention here that with respect to the fixed assets purchased by our client by virtue of cash credit facility of the bank, an interest of rupees 36,63,063 has been paid by our client up to 31/3/2023 to the bank. A sheet specifying the details on so and so. So this is basically compensation and damages. If Lordship comes to paragraph 7 also, same for purchase of land, for maintaining kitchen, for payment to the laborers, etc. These are all compensation and damages, Lordship. That is one. To my understanding, Lordship, these are all dead issues so far as paragraph 6 of the earlier judgment is concerned. For the arbitrator, dead issues for the arbitrator. If Lordship comes to paragraph 12, our next page, Lordship, our client is entitled to receive a sum of rupees so and so along with legal costs according to this process and interest at the rate of 12% per annum till the date for release of the above mentioned amount. So these are all compensation. No other interpretation can be given, Lordship. Paragraph 13. Now, what they want, Lordship. Eventually and admittedly, disputes regarding the claim for loss sustained by our client on account of arbitrary cancellation of the agreement have arisen, and hence our client by way of this notice hereby invokes the arbitration clause contained in the contract agreement dated 26/10/2018 under clause 56 arbitration, and it is to intimate you that an application under section 11 of the Arbitration and Conciliation Act 1996 shall be filed for appointment of the arbitrator as unilateral appointment of the sole arbitrator as suggested in the agreement is invalid and held to be void by the Honorable Supreme Court in the matter of so and so. So we are intimated. We are never asked to engage somebody as arbitrator from our side.
You cannot be, because after the judgment of the apex court,
Lordship.
the curated panel is.
Lordship, that is a judgment subsequent to the appointment of the arbitrator, Lordship,
Huh?
not prior to appointment of arbitrator.
Huh?
That is a judgment, Lordship,
Huh.
that was subsequent to the appointment of arbitrator.
But it lays down the
Initially-
law.
No, that is law, Lordship. But in this case, Lordship, we were never asked to appoint an arbitrator.
No. This is only a technical objection.
Yes, no.
You are
No,
not
no,
entitled to.
My
you are not
objection,
entitled
my
to-
objection is, Lordship, this is 11.6. Lordship, may kindly see 11.6. When your Lordship assumes jurisdiction for appointing, referring the matter to
No,
arbitration.
you, even if assuming that you are called upon, will you be able to appoint an arbitrator independent?
But this is not a challenge to the arbitration clause in terms of this judgment, Lordship. What they should have been, they should have
No,
done.
what they should have done or should not have done is a different issue, but you see, let us not be too technical.
Yes.
There is some dispute, which even the writ court, the coordinate bench has also held that they are entitled to claim their damages or whatever.
Those has been excluded. So
No.
far as claims and damages are, claims are, so far as damages and losses are concerned, that has been excluded. Now their only dispute they have raised in this representation, Lordship.
No. They are entitled for what? Damages.
No.
This is what the finding is.
No, Lordship. Court said for damages and compensation, you have to go to the civil court.
That's right.
Not to arbitrator.
No, but are you saying that civil court
But in
excludes the jurisdiction of
but-
arbitrator?
But in this writ petition,
In fact, section 8 is very clear that where there is an arbitration clause, the civil courts are bound to refer.
Lordship, to that aspect, Lordship, I am also having some judgment. I will definitely place it.
Hmm.
But so far as this representation is concerned, Lordship, paragraph 13, Lordship, here the dispute regarding the claim of loss sustained by our client, not any other dispute.
Yes.
If Lordship comes to 11.6, Lordship,
You raise these objections before the arbitrator.
that for
Who
that they will
story?
have to give us the opportunity to appoint one arbitrator.
No, where do you get that
That
provision?
opportunity was never given to us.
No, where, under what provision do you get that opportunity?
Under the arbitration clause 56,
Let us see 56.
118, Lordship.
My lord, the date of the MOU is also important, my lord. That was signed on 26th October 2018, my lord. And the judgment came in 2019.
118, Lordship.
8.
Paragraph 56.
Yes.
Arbitration. In the event of any dispute arising out of the contract between the parties, hereto, the same shall be referred to the sole arbitration of the state government or any officer appointed by the state government on its behalf. The proceedings held by the arbitration in making award will be in accordance with the provisions of the Indian Arbitration and
So
Conciliation
where is
Act.
the option to give the state, call upon the state to appoint?
Second line, Lordship, shall be referred to the sole arbitration of the state government
Correct.
or any officer appointed by the state government on its behalf. So we are a nodal agency. Once they invoke arbitration and request us to appoint one arbitrator, we will forward the matter to the state government. State government will appoint one arbitrator.
But in terms of the law laid down, you cannot appoint.
Who will decide that, Lordship? If they have any objection as regard
No, there's
appointment
no
or
question of-
jurisdiction of the
no,
arbitrator,
there's
that
no
is section
question of
33,
objection.
Lordship.
There's no question of
Section
objection.
13, Lordship. Section 13, Lordship, may kindly see. Section 13,
Yes.
challenge procedure.
Section
13.
Yes.
Section 13, subject to subsection 4, the parties are free to agree on a procedure for challenging an arbitrator. 2, failing any agreement referred to in subsection 1, a party who intends to challenge an arbitrator shall within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of the reasons for the challenge to the arbitral tribunal. Then who will decide, Lordship? It is the arbitral tribunal itself.
No. Arbitrator tribunal to be constituted,
Lordship.
the procedure laid down in the agreement is contrary to law.
That who will decide that, Lordship? As on date, Lordship, this is the
That is
procedure.
what we are required to decide.
No, for this, Lordship will have to set aside this provision.
No, why should we?
Then, Lordship, until and
Because
unless it
this
is set
law is
aside.
already clear that
No.
curated panel, if objected to, are not to be resorted to.
It is there, Lordship, but
Hmm.
for the purpose, as on that, this arbitration appointment, procedure for appointment of arbitrator is already there.
No. this
Until and unless
procedure-
this is set aside, Lordship.
No. Why should anybody go into setting it aside? It's a question of interpretation. This is a contract agreement. This is not a statute.
Lordship.
It's a contract agreement.
Yes,
On
it
the
is between
day
the
when
parties,
you,
Lordship.
on the day when you entered into an agreement,
Yes.
it was acceptable. But subsequently, it has been held that if there is an objection, it has to be, you cannot go for curated panels.
No, for at this moment, Lordship, under section 11(6), Lordship will only consider whether there exists a arbitration clause or
Exactly.
not. To some extent, Lordship, one judgment is there. Lordship will also have the authority or jurisdiction to see prima facie whether there any arbitrable cause of action
Yes.
is there or not.
Yes.
So my first submission is, so far as damages and loss are concerned, that will be the subject matter of civil court, not arbitrator. That is first my submission. Secondly, Lordship, as on date, we have not been requested to appoint arbitrator. We have only been intimated.
Your request for arbitrator cannot or will not permit you, perhaps, to appoint an arbitrator agreeable to the petitioner.
Lordship will definitely take a call on that point, Lordship.
No.
But in
No,
my
no.
humble understanding, until and unless the provision is
Taking a
there.
call depends on your stand. What is your stand? Supposing, hypothetically, you are given an opportunity to appoint an arbitrator.
We will definitely appoint one.
Of course, you will appoint.
And if
There's
you
no
have
question.
any objection as regard the arbitrator is concerned,
This is
you
a
will
very
raise that
technical,
objection
this is a
before
very
the tribunal.
technical objection you are raising.
These are not technical.
You
Lordship.
have
These are all
to, you
statutory.
can only appoint an arbitrator from the government.
Government will appoint an arbitrator.
All right, government is going to appoint an officer of the
Now,
government.
whether that will have any effect so far as 12 is concerned, Lordship.
Hmm.
The bar is where it is section 12.
Yes.
Section 12, under section 12, there is a schedule, Lordship, schedule 7.
Yes.
Let my friends show, Lordship, which particular provision
Who is the officer in charge here? Who is your employer?
My employer, my lord, Ekta Shakti Foundation itself is a society.
With whom have you entered the contract?
SSB.
Huh?
This is the nodal officer, Lord. And in my affidavit, I have clearly
Nodal officer, my lord.
clearly
District
stated
director.
that, Lordship, it's
Who
a
is the
state
state
central-
nodal officer?
State nodal, he said state nodal, in other state, Lordship, it's a different entity at all. In Assam, Lordship, the MDSSA, Lordship, has been given, also been given the charge of nodal officer. This
Midday meal scheme.
nodal officer, state nodal officer, and this midday meal scheme, Lordship, and this is entirely a central government scheme. This is not even a state government scheme. And that I have clarified in my affidavit.
Hmm.
So a scheme, Lordship, that is a central government scheme. One officer has been appointed, and the matter appointment of arbitrator will be done by the state government. Let my friends show, Lordship, in out of this 7 schedule, Lordship, there are 19, Lordship, grounds arbitrator's relationship with the parties or counsel. I am barred by which one?
You are holding the post of the.
I am MDSSA.
MD.
I am also holding the post of nodal officer, state nodal officer.
Therefore, how can you say that?
And it's a, no.
How can you say that?
No, first thing,
Because
Lord,
I'm
this is
dual charge, I'm
no,
two different persons.
no, so far as this nodal officer is concerned, it's only a scheme. It's a schematic post, Lordship. It's a coincidence that he is also holding the post of director assistant.
Whatever it may be, but he is holding.
He is not going to appoint the arbitrator.
Who is going to appoint?
It's the state government.
Who represents the state government?
State government, he is not representing the state government.
No, who is representing?
Lordship,
Which
Lordship,
department?
as per the procedure, Lordship, we are going to, once we receive a request from the petitioner that appoint one arbitrator, we'll simply forward this to the state government.
Which department in the state government?
No department has been mentioned, Lord.
Then?
No department.
How do you
We are
identify state government? Where do you send
to
it?
the chief secretary, Lord.
Chief secretary.
This is the procedure has been laid down, Lord. Arbitration clause 56. That is the procedure has been laid down.
Right.
So his first thing, Lordship, he is unable to show that any live issue is there to be adjudicated by the arbitrator. That is one.
Live
Secondly,
issue-
Lordship, under
live
section.
issue is on a different issue. We'll come to that. But first, tell us the procedure for appointment on the ground that you are entitled to appoint an arbitrator.
No, so far as Lordship for appointment, that is 56, Lordship, page 118. That is clearly mentioned, Lordship.
It
And
shall
select-
be referred to the sole arbitration of the state government.
Yes.
What is the meaning of that?
Somebody from the state will be appointed, Lordship. No, this judgment, Lordship, he is placing, Lordship, his judgment he has. Petition related to person. That Perkins is man, Lordship. That is only in the situation when I am covered by section, the schedule 7 of section 12.
No, there is a subsequent judgment where you cannot appoint.
No, thereafter,
Curated
Lordship, these 12.
If you interpret 56,
Yes.
that let them make an application, we will appoint somebody who is not hit by
Any of the ground in
50
the schedule
50.
7. Yes. No, let him specify, Lordship. This is the ground, serial number 1, 2, 3, 19, Lordship. Under this clause, you are barred to appoint an arbitrator. Will definitely accept, Lordship.
Yes. How do you respond to the objections?
My lord,
Lordship,
as
one
far as
judgment,
their
Lord.
appointment is concerned, my lord, thus the first objection that they have raised that they are not the actual authority, thus MOU was signed by the state nodal officer, first place, my lord.
No, you
Second,
come to
my lord,
56. 56.
56 clearly state that they have only specified that any officer from the state government will be appointed, my lord. They are not saying that any retired judicial officer shall be appointed. They are not on that point. They are saying that the officer from their department or from their state government will be appointed, my lord. Now they cannot exceed that part, my lord. Today they are making a submission that will appoint some another person. Now they themselves are saying in that clause, or any officer appointed by the state government on its behalf, man. It is clearly mentioned over there, my lord. Now they themselves cannot say today independently saying that we'll appoint some another person. Now
They have not said so. They have not
saying
said
that they will consider whether they will appoint their officer or not.
for
My lord,
which
we
you'll have
cannot submit
to
it.
demand an arbitration.
My lord, we cannot the moment we demand an arbitration saying under this clause, my lord, we are submitting ourselves to the arbitrary tribunal of the appointed
Not
officer.
necessarily.
Because that is barred, my lord, under the subsequent judgment, my lord. So we have come before your lordship that an independent person may be appointed. If they are agreeing on the arbitration, my lord, today, then an independent
They are
person
not
could be
agreeing.
appointed.
They are not
Because
agreeing
if-
for the arbitration.
My lord, they are saying that the damages and the cost will be adjudicated by the civil court, my lord. If they have a specific plea to that effect, my lord. They are relying on that judgment which has been passed by the Honorable High Court, my lord, this court. And herein, my lord, they are specifically saying that the specific performance is not now entitled to by the petitioner, my lord. Now, that means that they are also on the same line that we are on, and wherein it has been clarified that, my lord, in the subsequent paragraphs that the arbitration clause is there. If so advised, we can evoke that in arbitration clause, my lord. either the entire judgment has to stay, my lord, or they are objecting only a part of it, saying that the damages can be only be claimed by the civil court. Now there is a conflicting to that effect, my lord, under section 8 of Arbitration Conciliation Act.
You first address on the issue of appointment of arbitrators.
My lord, the clause itself says that refer to the sole arbitration of the state government or any officer appointed by the state government on its behalf, my lord.
Have you called upon them to appoint an arbitrator?
No, my lord, we have
Then-
not called upon, say, but we have issued
Then-
the notice saying that since there is a bar which has been created due
You
to
come to
subsequent
section
judgment.
11.
My- Appointment of arbitrators, my lord. And 6, my lord, may I come to subsection 6, my lord?
No, you read all the sections.
A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Subsection 2, subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Failing any agreement referred to in subsection 2 in an arbitration with 3 arbitrators, each party shall appoint one arbitrator, and 2 appointed arbitrators shall appoint the third arbitrator, who shall act as the presiding arbitrator. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, the 2 appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment. The appointment shall be made upon request of a party by the Supreme Court, or as the case may be, the High Court or any person or institution designated by such court. Failing any agreement referred to in subsection 2 in an arbitration with a sole arbitrator, if the parties fails to agree on the arbitrator within 30 days from receipt of a request by one party from the other parties to so agree, the appointment shall be made upon request by a party by the Supreme Court, or as the case may be, the High Court or any person or institution designated by such court. Where under an appointment procedure agreed upon by the parties, a party failed to act as required under that procedure, the parties or the 2 appointed arbitrators fails to reach on an agreement expected of them under that procedure, a person including an institution fails to perform any function entrusted to him or it under that procedure, a party may request the Supreme Court, or as the case may be, the High Court or any person or institution designated by such court to take the necessary measures unless the agreement on the appointment procedure provides other means for securing the appointment, my lord. The Supreme Court, as the case may be, the High Court, while considering an application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, degree, order, or any code, confined to the examination of the existence of an arbitration agreement. The designation of a person or institution by the Supreme Court, or as the case may be, the High Court, for the purpose of this section shall not be regarded as a delegation of judicial power by the Supreme Court or the High Court. A decision on a matter entrusted by subsection 4, subsection 5, or subsection 6 to the Supreme Court, or as the case may be, the High Court, or the person or institution designated by such court is final, and no appeal, including letter patent appeal, shall lie against such decision.
Yes, then
The Supreme Court, or the case may be the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in writing of subsection 1 or section 12, and have due regard to any qualification required for the arbitrator by the agreement of the parties, and the contents of the disclosure and other consideration as are likely to secure the appointment of an independent impartial arbitrator. 9. In the case of appointment of sole or third arbitrator in an international commercial arbitration, the Supreme Court or the person or the institution designated by that court may appoint an arbitrator of a nationality other than the nationalities of the parties, where the parties belong to different nationalities. 10, the Supreme Court, or as the case may be, the High Court may make such scheme as said court may deem appropriate for dealing with matters interested by subsection 4 or subsection 5 or subsection 6 to it. Number 11, subsection 11, where more than one request has been made under subsection 4 or subsection 5 or subsection 6 to the different High Court, or there designates the High Courts, or it designate to whom the request has been made, first made under the relevant subsection shall alone be competent to decide on the request. Subsection 12A, where the matter referred to in subsection 4, 5, 6, 7, 8 and subsection 10 arises in international commercial arbitration, the reference to the Supreme Court or the case may be the High Court in whose subsections shall be constituted as in reference to the Supreme Court. And where the matter referred to in subsections 4, 5, 6, 7, 8 and 10, subsection 10, arise in any other arbitration, the reference to the Supreme Court or as the case may be the High Court in whose subsection shall be constituted as a reference to the High Court within whose local limits the principal civil court referred to in clause E of subsection 1 of section 2 is situate. And where the High Court itself is the court referred to in that clause to that High Court. Subsection 13, an application made under the section for appointment of an arbitrator or the arbitration shall be disposed of by the Supreme Court or the High Court or the person institution designated by such court as the case may be expeditiously as possible, and endeavor shall be made to dispose of the matter within a period of 60 days from the date of service of notice on the opposite party. Subsection 14, for the purpose of determination of the fees, the arbitral tribunal and the manner of its payment to the arbitral tribunal, the High Court may frame such rules as may be necessary after taking into consideration the rates specified in the 4th schedule. Explanation: for the removal of doubt, it is hereby clarified that subsection shall not apply to the international.
What about 11.6b?
11.6b, Lordship, the parties or the two appointed arbitrator, this is not relates to us, Lordship. This is when a situation of 3 arbitrators. First one
Parties.
applies to us. 6a, a party fails to act as required under that procedure. Procedure means procedure laid down in the arbitration clause.
Mhm.
So we have a procedure.
Then B.
B, Lordship, when the 2 arbitrators fail to
No,
appoint.
no, you read B.
The parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure for the 3rd arbitrator. I mean the presiding arbitrator.
Just
The parties.
plain reading of 11.
The
6B.
parties or
I'm
the
concerned with the parties.
no parties mean when it's a situation for appointment of 3 arbitrators.
No, where do you get that? You read 11.6 or 11.5.
Yes, 11.6, Lordship. A, where under an appointment, Lordship, arbitrator may be sole arbitrator or it may be 3 arbitrators, Lordship.
Yes.
A applies when a party, when a request is made to one party and it fails to appoint an arbitrator within a period of 30 days.
No, you read 6 first. 6.
Where? Subsection 6.
Subsection 6.
Where under an appointment procedure agreed upon by the parties, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure. So it's a procedure of 3 appointed arbitrators.
No, where do you get that?
Lots of
See,
2
if you
arbitrators are
read-
already there.
If you read 6.
Yes.
It
Where
talks
under an
about-
appointment
It
procedure,
talks about an appointment
procedure. It
procedure
talks about
agreed upon by the parties.
and the procedure may be of sole arbitrator or maybe of 3
Whatever it is.
arbitrator. Lordship B, Lordship, if Lordship
Is
reads
where
B,
the party fails.
where the parties B, Lordship.
Uh,
Why I'm saying it is not applies to us, it
No.
applies to in case of 3 arbitrators.
No, that is not apparent from the.
Yeah, okay, Lordship, I'm reading once again,
It
Lordship.
may apply to 3 arbitrators or to the parties.
No, if the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure. So two arbitrators are already there. And the two arbitrators failed to appoint the third arbitrator, that is the presiding arbitrator, in that situation. So first, when there is a sole arbitrator, two, when there is a three arbitrators, in that situation, Lordship, this honorable court assumes the jurisdiction.
Is there an interpretation you are referring to from a judgment, or this interpretation?
Lordship.
Why can it not be interpreted that 11(6)(b),
Lordship,
besides being applicable to the parties, is also applicable in a situation where there are two appointed arbitrators?
So it's two arbitrators are already there.
All right, that is one, but it also applies to the parties.
Yes, it applies to the parties.
It doesn't say that the parties and the two arbitrators fail to reach an agreement.
No, parties means here two parties. Both parties fail.
Both parties.
So allegation is against us.
No, the parties fail to reach an agreement expected out of them under the procedure.
Not in that situation, Lordship will look into the procedure. In our case, Lordship, so far as 56 is concerned, only one arbitrator is to be appointed.
Correct.
And that is by the other party who has been requested.
No, you are trying to interpret 11(6)(b) to be specifically applicable only in case of two arbitrators.
Yes.
Where do you find that interpretation from?
Because two appointed arbitrators is mentioned there.
Yes, but it is a mutually exclusive of the term the parties.
Yes.
It is applicable to the parties.
This may also be a situation where the parties fail to appoint their individual arbitrator.
Could be, or one arbitrator.
Yes, I am also failed. He has also failed. That is a situation, Lordship.
Or
the two appointed arbitrators.
You not only fail, you fail to reach an agreement expected out of them.
Yes.
So
it
therefore,
will depend
in terms of the procedure laid down.
Yeah, so it will be depend upon what is the procedure.
Correct.
So in our case, procedure is for appointment of a sole arbitrator.
Correct.
So that is why I am submitting, Lordship. In our case,
according to you, you have not been called upon to appoint an arbitrator.
So
in case you are called upon, you will refer it to the government.
They will appoint an arbitrator.
Or may not appoint.
So there is no question of failure on our part.
Correct.
And until and unless there is a request or a failure on our part, Lordship, this honorable court will not assume the jurisdiction for appointment of
That is what I am saying.
That is my understanding, Lord.
No, your understanding has to be supported by law.
Yes,
by interpretation.
6A, Lordship.
6A doesn't say so.
Lordship, I am reading one second.
6A, 6 contemplates three situations.
Yes.
Number one, you fail to act as required under the procedure. Who fails to act? Which party? It doesn't specify that party A or party B.
Lordship.
It says a party fails to act.
The party who has been requested, if that party fails.
Those interpretations are not there. You have to read whatever is there.
In that situation, Lordship will have to read the entire act along with the
We'll have to, if required, we'll read the entire act. But the purpose of arbitration is, it is an exception to the normal civil litigation. And Section 8 makes it mandatory for civil courts that wherever there is an arbitration, refer it to arbitration. So the import of the law is that if there is arbitration, send them to arbitration.
I'm fully
and if
agree
the
with
parties
you,
can't agree,
but my only
if the parties can't agree,
yes,
Section 11 is one of the
so that is
avenues.
That is
And
what
when
my
it is
dilemma
there-
That is my failure, Lordship.
No.
In every situation, it says party fails. Two
Exactly,
appointed
but it
arbitrator
doesn't
fails.
say.
Where is my failure?
It doesn't say the party who's required to appoint. It says only a party. Which party?
Whichever may be, Lordship. The party who has
Let
been
us-
requested to appoint one arbitrator,
No.
or both the parties. Lordship, both parties will appoint
Let us
arbitrator
say-
when there is a.
Let us say 6A. Let us concentrate on 6A.
6A, Lordship, one party. A party.
A party fails to act.
Means the party who has been requested and he fails.
From where do you get that interpretation? See, it says that there is an appointment procedure agreed by the parties.
Yes, that is one. One procedure is already there.
Now
If
according to
Lordship
you,
comes to B,
according to you, A is applicable only when there is a notice issued on you and you fail to act.
In my understanding, Lordship, 6A applies
Only to
when there
those
is only
circumstances.
a sole arbitrator is to be appointed, and the party who has been requested to appoint fails to appoint one arbitrator within 30 days. In second case, Lordship will see the parties or the two appointed arbitrators. Parties means the parties, both parties fail to appoint their individual arbitrator, or that they appointed two arbitrators, but the two arbitrators fail to appoint the third arbitrator. That is B. And C is a person including an institution failed. This is not applicable to us. So first and two, so far as my understanding, it's 6A. Lordship is pointing to 6B. But Lordship, it will apply only in situations where procedure says 3 numbers of arbitrators will be there. So
See,
my
if
basic,
you look at 11.2, 11.2,
Lordship,
11.2 makes subsection 6 non-obstantive.
yes,
Subject to subsection 6, parties are free to agree.
that we agree,
You had agreed.
Lordship.
But the exception to that is given under 11.6.
Yes. When this honorable court will assume jurisdiction is subsection 6.
6.
So Lordship, for that Lordship, one of the party has to fail. Lordship, be it one party, be it two party, Lordship. In our case, no failure is there because we have never been requested. Who requested us, please appoint one arbitrator as per section 50, clause 56, Lordship. So that is my first, Lordship. So far as this dispute that has been invoked, Lordship, for under section 56, we are never requested to appoint one arbitrator. So there is no question of failure. And in that situation, this honorable court will assume no jurisdiction for appointment of an arbitrator. It is only in case we fail, Lordship. In that situation, Lordship will direct for appointment of an arbitrator. That is my first submission, Lordship. Secondly, Lordship, if Lordship comes to section 16, section 16, Lordship, it's chapter 6, 16.5. Section 16.5. The arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceeding and make an arbitral award. So this is relating to the jurisdiction of the arbitrator. If they think that in terms of Supreme Court judgment, this particular arbitrator has no jurisdiction to arbitrate this issue, then he has to raise this issue under section 16 before the tribunal itself.
Get it?
That is 2, Lordship. Thirdly, Lordship, for application of the judgment passed by the Honorable Supreme Court, petitioner will have to show that the arbitrator who has been appointed by the state government is within the relationship with the parties or counsel as described in section schedule 7 under section 12.5. He has also failed to do that. Lastly, Lordship, in my understanding, Lordship, in view of the judgment passed by the earlier judgment, Lordship, in this case, Lordship, this loss and damages is an issue dispute outside the ambit of the arbitration, Lordship. That has to be decided by the civil court. If other than that, if he has any other dispute, that may be referred to the arbitration. And so far as the representation is concerned, Lordship, other than that, he has no other dispute. So that is my case, Lordship. Now, one judgment, Lordship, I am placing, Lordship. Yeah, 2024, let's see, I'm like.
Yes.
Lordship, this is 2024 SCC online SC 1754. This is a three judges bench.
Yes.
If Lordship first comes to paragraph 33, Lordship, the page bilak nai likha na. Pages are not there.
Yes.
Paragraph 33, Lordship. Lordship, if Lordship comes to D, next page, Lordship D, issues for determination. I'm in the second issue, Lordship, small Roman 2. What is the scope and standard of judicial scrutiny that an application under section 11(6) of the Act of 1996 can be subjected to when a plea of accord and satisfaction is taken by the defendant? Lordship, issue may be different, Lordship, but it has relevance, Lordship. I'm coming to paragraph 83.
Yes. Yes.
Paragraph 83, Lordship. This court further held that the referral court, while exercising the powers under section 8 and 11 respectively of the Act 1996, could exercise its power to screen and knock down ex specie meritless, frivolous, and dishonest litigation so as to ensure expeditious and efficient disposal at the referral stage. Section 43, 148, it is a quote from another judgment. Section 43(1) of the Arbitration Act states that the Limitation Act 1963 shall apply to arbitrations as it applies to court proceedings. Subsection 2 states that for the purposes of the Arbitration Act and Limitation Act, arbitration shall be deemed to have commenced on the date. Lordship, I am skipping this paragraph, Lordship. I am coming to page 89.
The notice is issued.
No, not this paragraph, Lordship. It's a wrong paragraph 89, Lordship. It's the relevant paragraph.
89.
I'm sorry, Lordship. Paragraph 89. Lordship. We find it difficult to agree with the dictum of law as laid down in Indian Oil Supra, while the dictum in Vidya Drolia allows for interference by the referral court. It only allows so as an exception in cases where ex specie meritless claims and are sought to be referred to arbitration. However, the view taken in Indian Oil takes a position that which was taken by this court in Baghora Polyfe, wherein it was held that the issue of accord and satisfaction could either be decided by the referring authority or be left to the arbitrator to decide. This pre-2015 position, as was also pointed in Mayavati Trading Supra, was legislatively overruled by the 2015 amendment to the Act 1996 and the introduction of sections 11(6)(a). Thus, in our view, the intention of this court in Vidya Drolia was not to hold that despite the 2015 amendment, the position regarding accord and satisfaction would continue to be one which was taken in Baghora Polyfe. Vidya Drolia only went to a step ahead from the position in Mayavati Trading to create an exception that although the rule is to refer all questions of accord and satisfaction to the arbitral tribunal, yet in exceptional cases and in the interest of expediency, ex specie meritless claims could be struck down. If then Lordship comes to paragraph 91.
No, you have to take us properly through the judgment because there are several issues which are.
Then Lordship will come to the findings, Lordship, paragraph 92.
No, this is
What has been-
this 89 you have referred for what purpose?
Just to show
The
that,
claims are meritless.
yes, in that situation, whether this honorable court has the authority to scrutinize.
There is no dispute, there is no quarrel on the proposition that if the prima facie it appears that these are not arbitrable, there is no question of reference.
Yes, that's
The question, the
most
facts of the case is, according to you, the specific performance is.
So far as the facts is concerned, that
It
is
is not
definitely related to our case, but the law, one line only I would like to refer, Lordship, that is paragraph 92. So that is the ultimately what is the law has been laid down, Lordship. Paragraph 92.
Yes.
The position that emerges from the aforesaid discussion of law on the subject as undertaken by us can be summarized as follows. 1. There were two conflicting views which occupied the field under the Arbitration Act 1940, while the decisions in Damodar Valley Supra and Amarnath Supra took the view that the disputes pertaining to accord and satisfaction should be left to the arbitrator to decide. The view taken in P.K. Ramaya Supra and Nathani Stills Supra was that once a full and final satisfaction is entered into between the parties, no arbitrable dispute subsists, and therefore reference to arbitration must not be followed.
This is not the case.
This last two line, Lordship, I am referring.
No, this is not the case here.
This is not the case, but last two lines. If no arbitrable issues remain.
We agree that. The question is whether the issues are arbitrable or not in the first place.
And in my submission, humble submission, Lordship, in view of the earlier judgment.
The earlier judgment says no specific performance.
One. And
compensation.
For loss and compensation, you have to approach the civil court. So far as these two issues are concerned, these are not arbitrable. But what is the dispute?
Perhaps the first is foreclosed unless he.
So termination is no longer an issue, Lordship. That is one. Termination is no longer an issue. So it has been.
No, not termination. Specific performance.
Specific performance is not there, Lordship. So.
But the other aspect of
loss and damages. Loss and damages, he was given an entitled sentence. He is entitled to approach the civil court.
And also to invoke the arbitration clause.
No, that is what I'm trying to. One is section paragraph 6. Another one is paragraph 9. In paragraph 6, court said for loss and damages, you have to approach civil court. Ultimately, court says you can also be. You have also been given the liberty to invoke arbitration.
Correct.
But that is what I'm submitting, Lordship. Conjoint reading means so far as loss and damages are concerned, that is decided.
No, how is it decided?
It cannot be reopened in paragraph 9, Lordship.
No, how is it decided?
In paragraph 6, Lordship.
Assuming it is referred to civil court.
Yes.
Then also in view of the arbitration, the civil court has to refer it to arbitration under section 8.
No, first they have to approach the civil court. Civil court may refer it to the arbitration. That is a different issue.
Those are technical objections, Mr. You get a clarification from the coordinate bench to say what para 9 and para 6 or whatever it means. Subject to correction, our understanding is specific performance is closed until he goes for an appeal or further clarificatory orders.
That is one part.
The other is compensation. All right, civil court is normally do it, but arbitration is also one of the accepted means to claim it.
But that line is so specific, Lord.
No, it
so
doesn't debar.
It so specific. It is almost a bar, Lordship. If Lordship comes to that line, once again.
Record your submissions, but it does not debar.
Once again, so specific, Lordship. Page 165, right? It starts from paragraph 6, Lordship, 164. Last two line, Lordship, 164 last two line. Therefore, as the contract is found to be determinable in nature, the petitioner is not found to be entitled to any further specific performance of contract after lapse and or expiry of the contract period covered by the said MOU.
So this is with regard to reinstatement or restitution of the contract.
That is what I am saying, termination.
That is, he is
That
not
issue is
entitled.
over. Second lordship, at best, the petitioner would perhaps be entitled to approach the civil court for seeking damages and or compensation if so advised.
Hmm.
So if they want lordship for these two issues, compensation and damages, they can approach the civil court.
No, that's all right, but in view of the arbitration clause, where the court has also given liberty to invoke for what purpose?
That for any other issues,
What are the other issues?
other than termination and compensation and
What
damages,
other issues are there?
if it is not
You have
there,
to
it is
give-
not there.
No, you have to give a harmonious construction to the judgment. You can't take out one paragraph and say that this
No.
is irrelevant.
No, that is what I am submitting.
And this is
lordship.
a judgment of the court. It's not a statute. So we are not supposed to interpret judgments. Whatever is there is there. This last paragraph will have to be read, mean that either you go to civil court or go for arbitration.
Lordship will decide, lordship, but it is my understanding of the judgment, lordship. So far as these two issues are concerned, you have to approach civil court. Other than these two, if you have any other issue, then it's open, arbitration is open for you. That is my understanding, lord.
Yet what is there in this para 92?
Para 92, lordship, that para 92, first paragraph, lordship, last two lines. 92, small Roman 1, lordship may kindly see the last two lines. No arbitrable dispute subsists if the court is satisfied that no arbitrable disputes remain. Therefore, reference to arbitration must not be allowed. So if arbitrable issues are not there, unnecessary, there is no requirement for sending it to arbitration.
Number 2.
Number 2 is not related to our case.
No, it is.
Lordship.
You are reading the
Just
conclusions of the judgment.
No, for this one only, lordship, 92.1. And lordship may kindly also come to 6, lordship. Next page.
See, you
92.
are reading a judgment, please read it.
No, I'm referring to 92.1.
You can't refer to the paragraphs which are relevant for you. The
I can
judgment
read,
has to
it's
be
a
read
long
in its
judgment, lordship.
entirety.
That is why I'm trying
What
to
is the
skip.
conclusion of the judgment?
Lordship, I am specifically referring to 92.1 and 92.
What is the conclusion of the judgment in the judgment?
Lordship, my conclusion is that if the issue is not arbitrable, then there is no requirement of
But
sending
number
the.
2 says that certain areas where issues like payments to be whether made in full or not, etc., these can be referred to arbitration.
This is relating to the fact situation of this particular case. So I am referring to only two conclusion, lordship, that is 92.1 and 92.6. 92.6. 92.6, if lordship allows me to read, lordship. 92.6. Small Roman 6. The decision in Vidya Rolia, although adopted the view taken in Mayavati trading, yet it provided that in exceptional cases where it was manifest that the claims were explicit, time-barred and deadwood, the court could interfere and refuse reference to arbitration. Recently, this view in the context of accord and satisfaction, that is related to that particular case, was adopted in NTPC versus SMPL, wherein the eye of the needle test was elaborated. It permits the referral court to reject arbitration in such exceptional cases where the plea of fraud or coercion appears to be explicit, frivolous, and devoid of merit. I am not on it, lordship. I am only in this issue, word, lordship, deadwood. I mean, there is no live issues.
What is the meaning of accord and satisfaction in terms of the judgment?
Lordship, in that situation, lordship, both the parties has already in an agreement that performance has been satisfied, lordship. That is a different situation, lordship. That relates to
This is only with regard to fraud and coercion.
Yes.
Where there is fraud and coercion, then ordinarily
Lordship, explicit, time-barred, and deadwood. These two words are there. explicit time barred and deadwood. This is 6 lordship, 92-6. And so far as 92-1 is concerned, no arbitrable dispute subsist.
93 is perhaps the conclusion.
Thus, the position of the decisions in Mayavati trading and Vidratrolia is that ordinarily the court, while acting exercise of its powers under Section 11 of the Act of 1996, will only look into existence of the arbitration agreement and would refuse arbitration only as a demur when the claims are explicit, frivolous, and not arbitrable. That is a conclusion, Lord. So as one judgment has been placed by my friend Lordship at the very inception that on court will only look into existence of an arbitration clause and nothing more than that. That is not the actual position of law. Lord.
Ordinarily.
Yes, Lord.
Ordinarily.
That is ordinarily that is the situation. But when it appears to your Lordship that no arbitrable issues are there, then Lordship may not feel it necessary to refer the matter to the arbitrator. So that is one judgment, Lordship. Second judgment, Lordship, it 2001 SSC online. Surrender Kumar Singhan. All right.
Yes.
Let me submit my lord. To that effect.
Two more
points.
and a judgment is a deferral.
My lord, only to that effect, my lord. My lord, while observing the orders which has been passed by this Honorable High Court, there was specific to that effect that specific performance is now been terminated. The termination has closed the specific performance of the contract part, my lord. But there is no observation to that effect that damages and compensation are not entitled to by the petitioner, my lord. If that is an observation, therein the entire situation of the contract was looked into it by this Honorable High Court, my lord. First place, my lord. Secondly, my lord, while referring to Schedule 7, my lord, by my learned friend, my lord, therein the first point itself says that the employee, the arbitrator is an employee. If he is an employee, then he cannot be an arbitrator of the tribunal, my lord. So 7 schedule covers that part, my lord. As far as this clause 56 is concerned, my lord, it specifically says that any officer appointed by the state government on its behalf. That means the employee of the state shall be the officer who shall be appointed for the arbitral tribunal as its arbitrator, my lord. Under such circumstances, that is hit by Schedule 7, my lord.
All right, we'll continue. Further hearing.
Instruction.
14th,
Lordship.
14th August.
After 15th month.
Then it after 22nd, Lordship. 21 to 22nd, Lordship.
The last part of the August month.
No, then we'll forget everything. We want to close this matter. So we want to continue with the hearing so that we also remember, retain some of the arguments which are made.
Yes, yes.
We'll have it on 14th.
My lord.
Further hearing on 14th.
Obliged.
Highly obliged, my lord.
I think 60 and 61.
May it please the Lordship. So we take up the item number 61 first, Lordship.
61. Yes.
The content matter, Lordship. The order is at page 9 and the operative part is at 23 and 24. Para 41.
Yes.
Contempt. Accordingly, the state government is directed to create a personal post of head assistant, if needed, to accommodate the petitioner as head assistant in the Panchayat and Rural Development Department, Government of Assam, Hailakandi, Jila Parishad. It may be noted that the post of head assistant was very much in existence in the DRDA, which was earlier occupied by Sri Santiranjan Pal, but became vacant after he resigned from his service. As the absorption of the petitioner to the post of head assistant is assistant in the Jila Parishad has remained under a cloud which has been dispelled now, let the state government take appropriate steps for accommodating the petitioner as head assistant in Hailakandi Jila Parishad and release all the pecuniary benefits, including arrears, and grant other service benefits attached to the post of head assistant, which exercise shall be undertaken within a period of 4 months from the date of receipt of the certificate copy of this order. This order was on
15/8/11.
15/8/11.
11/2018, yes. Then not complied.
15/11/2018.
Not complied.
Not complied. That order on 28/12/2018, we furnished the copy. After more than 1 month, no.
Yes.
Thereafter, since no order was not complied, we have filed this contempt petition. It was filed in the month of January, December 2019. After almost 1 year. After filing this contempt petition, in the year 2021, the petitioner died. Thereafter, the wife of the petitioner was substituted. After substitution,
Not substituted were in the contempt.
in the contempt also. After the death, the service benefit, it is CPF amount that was released to the petitioner on 12/4/2021.
What further amount remains?
Now, Lordship, what happens as per the direction of this honorable court, arrear was also directed to be paid, and arrear to the post of the head assistant, Lordship. Since the year 2017, that is from the date of merger, the petitioner, late petitioner, has not paid any amount as salary. So the petitioner is entitled the salary of a head assistant from the date of merger till the date of his death. And thereafter, Lordship, what happened after filing this contempt petition, the order, an order was passed for creation of post in the year 2022 after the death of the petitioner. What is the stand of the respondent is that they did not have the knowledge of the death of the petitioner. Now, I have filed the item 60, that petition, whereby I have furnished copies how the petitioner, how the department was aware of the death of the petitioner.
No, so far as this order of 2018 is concerned.
Yes, Lord.
For which you have filed a contempt.
Yes.
What have you received and what is required to be received?
I have received nothing as per the order of this honorable court.
Nothing.
Nothing. Because after the death, that CPF amount automatically will come to the wife.
So you were asked to be given the arrears
of the post of head assistant.
Head assistant.
Yes. Create the post if necessary and pay the arrear of head assistant from the date of merger. Because my claim was in the earlier petition from the date of merger. So
when did he expire?
He expired on 17/1/2021.
What about the respondent? What is your stand?
My lord, I have filed my affidavit, my lord.
Where?
In the contempt also, my lord. And as well as the repetition also, my lord. In the contempt, lordship may kindly have page number 31 of my affidavit. This is the explanation, paragraph 4. May I read, my lord? That your deponent begs to state that as regard to the paragraph number 1 of the contempt petition, it may be stated that in compliance of the judgment passed by the honorable court dated 15/11/18 in WPC so and so, the government in PNRD department with concurrence of the finance department, write their UO so and so number dated 19/7/22, conveyed approval of the creation of the personnel post of head assistant under Panchayat and Rural Development Department at Hailakandi Zilla Parishad to accommodate Sri Shamal Nandi, the petitioner, WPC so and so, by government order dated 24/8/2022. The order was, my lord, to create a post and then promotion, my lord. Thereafter, he will get the benefit. But during the promotion, my lord, the petitioner expired, my lord. And the post was also created, my lord. But after, as the petitioner were expired, that was abolished later on, my lord.
This order was passed only to save from contempt.
No, my lord.
Because they had the knowledge of the death of the petitioner.
But now post was created, although late, but it was created. But he expired.
But I am saying that, Lordship, on 17/1/2021, the petitioner was expired. They had the knowledge.
You filed the petition, you filed the contempt petition when?
No, contempt petition was filed in the year 2019.
19.
After 4 years, they have.
Why did you not press the contempt petition then and there? 2019, you have filed the contempt petition.
Yes, Lord, sir.
He expired in 21.
Yes, Lord.
What happened in the
Contempt
meantime?
petition was
COVID.
listed in the, we entered in the petition later, Lord, sir. Like, I cannot answer that. Only thing is that, Lordship, petitioner died in 2021. Then, 12/4/2021, the CPF amount was released by the government. So they cannot say that they did not have the knowledge of the death of the petitioner. Despite having that knowledge, they did not do anything, and only to save from the contempt, they have issued that order of creating a post. The date of release of CPF amount was 12/4/2021, and the compliance order was of 2022. So it is only with a view to save from the contempt, Lordship. It is a clear case of contempt.
No, my lord.
They have deliberately avoided compliance.
You want to send them to jail?
Lordship, my purpose is that I should get the benefit, financial benefit.
Financial benefit subject to the person being accommodated in the personal post, but he expired before that. What is the specific direction of the court?
Lordship, I go to that once again. Page 23 of the contempt petition. So I come to page 24, page para 42. As the absorption of the petitioner to the post of head assistant in Zilla Parishad had remained under cloud, which has been dispelled now, let the state government take appropriate steps for accommodating the petitioner as head assistant in Hailakandi Zilla Parishad and release all the pecuniary benefits, including arrears, and grant other service benefits attached to the post of head assistant.
Well, 41 is the main.
Why so much of delay from the date of
My
order
lord,
till the creation of the post?
My lord,
Why
after
4 years of delay?
My lord, we have to go through the different departments, my lord, to create a post, my lord. The finance department, the judicial department.
You get the files, we'll see how much of delay, who has taken.
For in the second case, they are praying for the, my lord, notional benefits, my lord. And I can place the record, my lord. If lordship wants me.
No, we don't want to see your records. If you can give us a proper explanation that when there is an order of the court,
My lord,
you take 4 years and the person dies.
my lord,
And now you say this order cannot be implemented.
my lord.
Who is responsible for that?
My lord, for that I have to call the record, my lord.
And then
Lordship, if fix another date, my lord, I'll produce the record.
already this is more than 4 years,
My lord.
2019.
But this is my, yes, my lord.
Huh?
I'll produce the record, my lord. And the respondent here in my lord, he transferred long back ago, my lord.
You call him out of transfer wherever he is. This kind of excuses
I'll
are
produce.
not acceptable when there is an order of the court which has been left deliberately not complied.
My lord.
There is no appeal, there is no review, there is no prayer for extension of time.
My lord, we are trying our best, my lord, but some delays were there.
We will ensure that the salary of the hearing officers will be deducted to be paid to the account of the widow of this person. Because this order, if we find that the order was deliberately left to be not complied with.
My lord. The delay part I will satisfy.
You have to give an explanation why for 4 or 5 years it was not complied.
My lord.
And in spite of a contempt petition being filed.
My lord. I'll satisfy your lordship on that point, my lord.
You better satisfy us.
My lord, my lord.
You produce the records next week.
My lord. My lord.
And what is to be done in the writ petition?
In that case, lordship, I have made a prayer for payment of
notional benefit.
Notional benefit. That
Notional to which post? Head assistant.
head assistant, lord.
Has he been appointed there?
No, lords. But there
You, in terms of this order, if you comply, we will think about what orders we should pass. Otherwise,
My
you
lord.
are all guilty of contempt.
My lord, I'll satisfy, my lord.
You are guilty of contempt. We'll draw up contempt proceedings and will ensure that strictest of the orders are passed.
My lord, I understand.
You please convey to your clients.
Yes, yes.
This kind of conduct is not appreciated.
My lord, I'll.
Mr. R. Sharma for the petitioner, Mr. S. Dotto appearing for the Panchayat and Rural Development.
It's a contempt, in contempt matter. I'm
Contempt matter is, you're appearing for respondent?
My lord. My lord, I'm appearing for respondent number 1 and 4, my lord.
Respondent number 1 and 4. And Mr. Borua appearing for
4 and 5. This year.
4 and 5.
In the repetition.
Not in the contempt.
Contempt actually I don't have to.
You are appearing for 1 and
4.
4. And in the writ petition?
Writ petition, my lord, I'm appearing as a standing counsel PNRD.
For the PNRD department, in the writ petition. And Mr. CKS Borua for the state government. The standing counsel, Mr. S. Doctor will apprise the court on the next day as to why, in spite of a specific direction passed by the court, by its order dated, passed by this court, by order dated 15/11/2018, passed in WPC 5725 of 2017, to the effect that the state government was directed to create a personal post of head assistant to accommodate the petitioner as head assistant in the Panchayat and Rural Development Department, and to release all pecuniary benefits, including arrears and grant other service benefits attached to the post of head assistant. And which exercise was directed to be undertaken within a period of 4 months from the date of receipt of a certified copy of this order. Stop. This order, although passed, is although an inter-party order, Notwithstanding that, the order was communicated to the Principal Secretary, Government of Assam, Panchayat and Rural Development by communication dated submitted by the petitioner's late husband, as he then was, and which was received on the office on 28/12/2018. In spite of that, in spite of the specific directions, the order has still not been complied with, and in the meantime, petitioner's late husband expired on
17/1/2021.
17/1/2021, and pursuant to which the present petitioner has been substituted as a petitioner in both the contempt as well as the also in the writ petition.
No, writ petition filed after the
In the contempt petition. Stop. Let this in instructions, information be furnished to the court by the next date fixed. 20.
My
20
lord,
August.
Wednesday.
Lordship, can it be 1 or 2 days prior or back?
Prior.
22nd.
Prior or back?
22nd.
26th.
Yes.
22nd.
High level.
My pleasure also. In this case, the respondent on 9 and 10 has filed their affidavit on 14/7/2025. As well as the respondent on 1 has also filed their affidavit. Also, I need 3 weeks time for filing our reply.
Mr. K. Kolita, counsel for the petitioner, prays for 3 weeks' time to file rejoinder affidavit to the affidavits filed by the respondents. Prayer allowed, not objected to by the anyone for the respondents. Is Dr. Panchayat.
Yes, my lord.
And Mr. C.K.S. Barua for
Number 4.
respondent number 4. The respondent counsels do not agree to the prayer made. List after 3 weeks.
Interim may continue.
Some interim order, if any, will continue until further orders.
Hello.
63 is a case of removal lawsuit. We have filed affidavit here, original record is required lawsuit. One should come from Rajasthan and one from Delhi lawsuit, 2 records.
2 records.
Two records.
2 petitioners or what?
No, lawsuit. One petitioner is there, one is appellate order, one is lawsuit.
Already, they have filed their affidavit.
We have filed affidavit lawsuit.
Already, they have filed their affidavit.
Counsel for the parties, pleadings have been exchanged. Issue all for the relevant records of the case. Matter be listed for hearing in the month of September.
Fix a date, man.
September, let the records come. I can mention. This is a departmental proceeding.
Departmental proceeding.
The learned CGC will ensure the relevant records pertaining to the departmental proceedings leading to the dismissal. The writ petitioner be made available for perusal of the court if the need so arises at the time of hearing.
In this matter, affidavit has been filed and reply has also been filed. Matter may be taken up on Tuesday, my lord.
Why?
Miss MD Bora was unwell, my lord, she had to leave.
We'll issue rule then. We'll issue rule. Fix for hearing.
My lord, maybe it be fixed for hearing on 12th.
Not on 12th. It'll be in September. What is the matter about?
For promotion, my lord.
You are still in service or retired?
No, my lord, I'm in service. My lord, all the merits are there, my lord.
Oh, heard. Counsel for parties. Pleadings, you have filed your rejoinder and everything?
Yes, my lord.
Pleadings are complete, issue rule, matter be listed for hearing in the month of September.
All right.
Again, 71.
Lordship, we want to file our affidavit for respondent number 2, 3, and 4. Lordship may kindly give us 2
Why
weeks.
is it for hearing?
My lord, it is
Item 60?
71.
71.
71. You want to file affidavit? Mr. MS so-and-so, learned counsel appearing for the respondent. Which respondent?
Respondent number 2, 3, and 4.
Respondent 2, 3, and 4, 6. Further time to complete her instructions and file necessary affidavit.
Lordship, my senior Mr. J. Roy, his name is not reflected in the cause list.
His name need not be. Your name is enough. Matter be listed after
2 weeks.
2 weeks.
My lord, a date may be fixed, my lord.
29th.
Much obliged.
For hearing item 65.
Lordship, we have filed the affidavit, Your Lordship. It relates to disciplinary proceeding. Your Lordship, here, Your Lordship, record will be required. Because they are disputing that this is not under Rule 7(5) of the Assam Services and Discipline Rules. It is under FR 56B.
Any other day, Tuesday or Thursday, hearing day, matter may be fixed.
Hearing day.
Hearing day.
Then it will be September.
Prior to September. In this month. During this
2nd September.
prior to any date.
Prior to is difficult. 28th
28.
or 26th September. August.
August, yeah.
28 will be better.
Huh?
28.
26th.
26th.
Once an early date.
Publish.
Heard counsel for parties. Matter be listed for hearing on 26th as prayed for by the learned counsel for the parties. Mr. K. Kaur, additional AG, appears for the state. The departmental records relating to the proceedings initiated against the petitioner be kept available for perusal of the court on the next day.
Obliged.
Publish.